Welcome everybody to Garden Court Chambers. Thank you so much. It's an absolute delight and a privilege to welcome you here today. My name is Aubrey-Johnson and I help convene the children's rights team here. Before I go any further, I have to tell you that this event is being recorded and the recording will be uploaded to our YouTube channel, and a recording link and the slides will be sent to all delegates. We are not expecting a fire alarm, so if the fire alarm rings, you need to exit this room the way you came in, walk down the stairs and leave the building and congregate at the gate in the fields. If you need comfort break, the toilets are on this corridor and there are also further toilets downstairs, and we're delighted we're going to be offering refreshments in the tea break after the event. So it's such a nice feeling to have so many people physically present in the building. I just wondered what your Wi-Fi is planning to us. The Wi-Fi? Yeah. I'll get somebody to help them. And the reason we have a children's rights team in Chambers is because we are a multidisciplinary set. We have a huge range of expertise, and we really want to use that expertise to build our ability to protect and defend children's rights. And today is a real showcase of how children's rights intersect all areas of law, from criminal to family, to community care, to immigration. So I hope that it will enable you to better represent the children who come to you presenting with legal issues, because they do not understand the legal issues they have. They do not know whether they need a criminal lawyer or a family lawyer. And sometimes they need more than one type of lawyer, and our silos of expertise can sometimes be barriers to getting them the help they deserve. So it is now a huge privilege to introduce Kathryn Cronin, who is one of our practitioners who has shown how building that intersectional expertise can protect children's rights. And she has done so in such a way that she almost needs no introduction. But she has extensive knowledge of immigration, asylum and family law practice, and she is known for a representation of vulnerable clients, in particular in asylum and human rights cases involving women and children. And she's been ranked for immigration, band 1 and family law in Chambers and Partners 2023. And to Kathryn, who's going to be talking today about trafficked children, the family and care jurisdiction.
Well, I repeat the refrain that it's fantastic for us to see all of you here, largely because our experience of dealing with trafficking is the experience of needing to have a perspective that goes across jurisdictions. And we luckily have the organisational base that those sort of necessary questions that one has when you're dealing with children in multiple litigation contexts, or where a child actually could benefit from accessing another litigation area. You do have people here who are, first of all, able to take the case, but also in other respects able to provide necessary information and assistance to the case that you're engaged with. I've written a very short paper, and it's a paper that just really wants to advertise the notion that very often you have children in the immigration jurisdiction and they would greatly benefit by being taken as well into the family jurisdiction, where you have a much better focus on their protection and their need for protection rather than whether or not they stay in the jurisdiction. In this terrible time, and it really is a terrible time for all of us looking at the legislative arrangements that are proposed to bring into force, what we can say with a chink of light is that most of the legislative framework dealing with trafficking is intact. And so the protection model is still there, able to be accessed. And we also have a sense that you have this varied jurisdiction if you are caught particularly with immigration, with the restrictions that are being imposed there. You may have a capacity to seek protection via another jurisdiction. I wanted to just start off with a sense of what the illegal migration bill is hoping to produce for us. There's a wonderful analysis done by the Refugee Council. It should have been done, of course, by the Home Office, but they're remarkably quiet on it. But in that analysis, the Refugee Council has estimated conservatively that if the illegal migration bill becomes law, that within the first 3 years after the legislation comes into effect, and I'm giving the broad figures rather than their very much more precise figures, but roughly 250,000 people will have had their claims deemed, their asylum claims deemed inadmissible. And these figures include some 45,000 children who have a need for protection and can't make, and are not permitted to make the protection claim. And at the end of the 3-year period, according to their figures, approximately 200,000 people will have had their asylum claim deemed inadmissible, but they won't be removed. And when one thinks of that, you know that what you have is this very large cohort of people who are going to be in need of ancillary protective arrangements because they can't access the appropriate protection through the immigration system. These stranded and unprotected, and some of them will be very young children, because the Home Office always works on the assumption that all the children that come in here are aged between 16 and 18. In fact, increasingly, you are getting 9 and 10-year-olds coming here by travelling on their own. So there is the issue of these children who are very often at high risk of trafficking. And it's in those cases that you will need to understand how to provide them with protection from the outlying jurisdictions rather than necessarily be able to remedy their situation through the immigration system. The family jurisdiction, which of course is only going to cover these children up until 18, but prior to that time, one can set in place the sort of protections that carry them over. And recently, Amanda Weston and Naomi Wiseman, Naomi having left Chambers, but both of them, it was a Chambers case, tried to get some assistance through the family court by invoking Article 39 and the wardship jurisdiction in respect of children that go missing from hotels. And we know from reading our newspapers that that's a fairly large cohort of children. The court denied the wardship relief. But what they've said is this, is that wardship for missing unaccompanied asylum-seeking children, it's marked by the fundamental constitutional principle that where there is a statutory scheme, the court should only use its inherent jurisdiction if there is a lacuna. And of course, what we're going to have after the illegal migration bill comes into force is the lacuna. So although that was not a successful case, because as it stands, the arrangements for protection for children are there, one certainly can say that after this legislation comes in, the wardship jurisdiction may very well be on offer in terms of providing them with protection. As it stands as well, of course, as everyone here will know and will have a good deal of information imparted about the importance of Article 10 of ECAT and the need to take into account the special situation of child victims. And I must say that I have relied on the sort of guidance that you often find in departments like Education Department as being helpful guidance that you again can feed into the immigration jurisdiction, where there is an emphasis that there's such a high risk that a child can go missing from care. And it sets out in quite precise details the steps that must be taken by carers, local authorities, schools and police to reduce the risk of children going missing. So you do find, although you're hog-tied, as it were, in the immigration jurisdiction on occasions, that these other forms of jurisdiction provide the very guidance that that courts can listen to. The case that I wanted to just flag with you, because it's a really important case, but it's tucked away in the lower court structure of the family court. It involves Mr. Justice Jackson, and it involves an application made for a care order for 2 Afghani children. They were then aged about 10 and 9 was their estimated age, and the court made clear that these are children had come on their own from Afghanistan, exactly the sort of caseload that we are now starting to see more frequently. The court recorded that the children, there was an attempt to find and contact their family back in Afghanistan, and like all such inquiries, it came to naught. So they had no information from the family and only rather scattered information from these very young and vulnerable children. And the court was asked to determine whether or not a care order was appropriate. And the judge set out, first of all, the fact that the court has jurisdiction, and it has jurisdiction either because these children had been long enough there to acquire a habitual residence in the UK, or they had no habitual residence because they had severed their contacts with Afghanistan. And in either of those situations, the family court has jurisdiction to deal with a care order. And then the court also looked at whether or not the threshold requirement for the child having suffered harm and to be in risk of harm. And on the harm threshold, the court said that the children had certainly faced, through their unaccompanied journey, significant harm, and that was sufficient to justify the court intervening in the particular case. It made clear that the children may have been sent out of Afghanistan for their own benefit, but that doesn't stop the court accepting that the threshold of harm had been reached. The court also scrutinised the proposed care plan for the children, and that was for their placement in a long-term foster home with the future possibility that a special guardianship order may be the appropriate outcome. And that assessment is something that is really worth looking at, because what the court noted is that if you look at the 2 forms of protection that children can acquire through a family jurisdiction arrangement, the looked after care is only barely care in many instances. But when you have a care order, you have a dedicated social worker, you have a care plan, you have generally always a placement in a family context that is intended to be permanent or semi-permanent, certainly during your childhood. And there is much more emphasis on getting for children the education, the medical help, and all the other ancillary needs and benefits that these children require. And so it is a very careful analysis about why you may opt for one care option than the other. And the court also expressed the hope that then this is a 1917 case, so, or 1919, it might be, I'll give you the reference. But at that stage, there was a prospect of improvement in Afghanistan, and the court indicated that if they were settled with a foster family and if they were proposing to go and get a special guardianship order, it really ought to come back to a judge in the family court so they could scrutinise the notion of how permanent the children's arrangement should be, and also make arrangements for the children to still have some immersion in their home and birth culture, so that that would not be lost and they would have that birth link maintained. So it's a truly excellent case in terms of refugee cases, and one that is well worth resorting to at different times. I think just wanted to note it. I think I'll just give you the reference. Oh, it's on. You'll have it on your paper. So I think just the last thing that I would say is that these sorts of arrangements, I think we have to assess what are the benefits for trafficked children in particular. And I've said that there may be resistance to a care order because they are expensive and they're much more elaborate than simply giving them a looked after target. But as a looked after status can be cancelled, and very deliberately the legislation leaves it open-ended, and so one can foresee that there could be the resiling of a looked after status of a very young child. It may well be that the care order is the appropriate and becomes the standard mode of protection for these children. And I will leave it there.
Thank you so much, Kathryn. That's a whistle-stop tour to provide us with the insight of how these two jurisdictions might provide protection, but particularly the family jurisdiction may afford unaccompanied children in particular protection that they are entitled to and deserve, and I think best meet their needs. So thank you. We have two sessions today, and the first is on duties owed to child victims of trafficking to stop re-trafficking and re-victimisation. And I'm going to turn first to Georgie Rea, who is another impressive multidisciplinary practitioner who has a broad public law practice while specialising in immigration and asylum, housing, education and community care. And he is going to talk to us about the statutory guidance for local authorities on care of unaccompanied migrant children and child victims of modern slavery.
Thank you very much, Kate, and thank you, Kathryn, for highlighting the importance of having a cross-practice and cross-jurisdictional approach to children's rights, particularly when, as we heard in the Refugee Council report, the plan to detain refugee children under the new illegal migration bill could affect up to a staggering 45,000 children. So, as Kate said, I'm going to be talking about accommodation. Yes, I'm going to be talking about securing accommodation for unaccompanied asylum-seeking children, particularly pending a case law compliant age assessment. Now, there's two reasons this is particularly prevalent at the moment. Now, firstly, we've all seen the news and probably have clients who are unaccompanied asylum-seeking children presently being accommodated in hotels. And these children have no one responsible for them, and they aren't accommodated under the Children Act in the first instance, and the Home Office is not acting as their corporate parent. Many of these children go missing, and they're either trafficked for the first time when they do go missing, or they are unfortunately re-trafficked. We at Garden Court did a presentation a couple of weeks back called Barracks, Barges and Hotels, which I would urge you to have a look at on our YouTube channel. And we assessed the conditions that these children are living in hotels at the moment. But secondly, with the illegal migration bill looming over us, This bill has created a power under what I think, following the most recent amendments, is clause 17, which means that the Secretary of State can provide or arrange for the provision of accommodation for unaccompanied asylum-seeking children themselves. And so normally this is a jurisdiction that local authorities would be providing the care. But the Secretary of State not only can, in the first instance, accommodate them, but they can direct that the local authority gives them back to the Home Office, even if they are in perfectly suitable accommodation. And one proposed amendment, which we're glad to see, is Amendment 4A under clause 17, which means that the Secretary of State for the Home Office will only be allowed to direct transfer back into Home Office care where it is in order to safeguard and promote the welfare of the child. I can't imagine in any instances where it would be in their best interest to be transferred to the Home Office, but we'll see how that all plays out. So we know that there are extensive delays both in processing asylum applications and in completing case law compliant age assessments. So it's of the utmost important that unaccompanied children, especially victims of trafficking, are provided with proper support and accommodation, not least to avoid future exploitation, but to enable integration into the UK and facilitate other fundamental rights, such as accessing education. So I'm not going to be going into the substance of age assessment law, which could fill an entire seminar. And I know that my colleague Nadia, who will be speaking later today, did a presentation on the current state of play with age assessments in Chamber's response to the illegal migration bill. But I'll be approaching the topic of securing accommodation with a four-stage approach. So firstly, we're going to be looking at the statutory guidance. So that's the local authorities' guidance for care of unaccompanied migrant children and children of victims of modern slavery, the most recent version being published in 2017. And then we're going to be moving on to the case law of R on the application of S against Croydon Council, heard in 2017, which is particularly useful in making it clear that there is a duty to treat age-distributed children as children unless and until the case law compliant age assessment is completed. We're also going to be looking at the age assessment guidance, which isn't binding, but is relevant to whether or not the statutory guidance has been complied with. And finally, looking at the importance of ensuring that we secure accommodation for our clients as soon as possible, especially if they're approaching their 18th birthday on their claimed age. So when I was researching the re-trafficking risk of particularly of unaccompanied children, it's shocking that neither the National Referral Mechanism guidance nor the Care of Unaccompanied Migrant Children guidance specifically refers to this concept of re-trafficking. And identifies someone as a previous victim of trafficking as being at any particular risk. But the Independent Anti-Slavery Commissioner, in their report of November 2021, not only highlighted this lacuna in the guidance, but identified that it is people, and particularly children, who were previously trafficked that are most vulnerable to re-trafficking. And the International Organization for Migration database showed that there was a crossover between those who have been internationally trafficked and those who will then be subject to internal trafficking. So if we have a child that has been trafficked before reaching the UK and is then placed in unstable accommodation in the UK, there is a greater risk that they will be subject to trafficking thereafter. And as I've already said, there's a significant risk of children going missing from care, especially when that care is precarious. So we have Section 20 of the Children Act, which I'm sure you're all familiar with, but it requires a local authority to provide accommodation, and this is an absolute duty where the child is in need, and unaccompanied asylum-seeking children are by definition in need. And once a child has been accommodated for more than 24 hours, they become a looked after child, and that's also made clear in the guidance. The duties towards asylum-seeking children is exactly the same as those to any other looked after children, and assessment and care provisions should be the same irrespective of whether an asylum claim has been submitted yet. So it's a significant duty. The age assessment guidance highlights that trafficked children will go missing in many cases within 48 hours of becoming looked after. So it's really important that there is planning for potential victims of trafficking, and placement in foster families particularly can mitigate this risk. And social workers should give consideration to whether they need extra support to highlight the vulnerabilities of re-trafficking. In the Modern Slavery Act, we find the presumption as to age. So if a public authority has reason to believe that a person may be a victim of trafficking and they're not sure about age, then until the age assessment is carried out, the authority must assume for the purposes of its function that the person is under the age of 18. And this is reiterated in the ACDS guidance, which states that where a person is in doubt, they must be treated as a child unless and until a full age assessment shows the person to be an adult. So how can we ensure that local authorities are exercising this duty when there is a dispute about age? If some form of age assessment has been completed, our most natural thing will be to bring a challenge by way of judicial review, either in the upper tribunal, either to be transferred to the upper tribunal or the High Court. But that doesn't solve the issue of a local authority refusing to accommodate them in the meantime. But it's clear from the case law, and in lots of our cases, we do secure interim orders for Section 20 accommodation pending the outcome of the age assessment. There I cite A and Cronin, which states that, as we know in age assessments, the question is one of objective fact, which is for the court to be determined. And so it falls rightly within the court's jurisdiction to also order Section 20 accommodation pending the final determination of a person's age. So this is the go-to case, really. This is S and Cronin, determined in 2017, that sets out the binding nature of the statutory guidance for unaccompanied asylum-seeking children. And the version of the guidance at the time, that was the July 2014 guidance. And it said that where a person's age is in doubt, they must be treated as a child unless and until a full age assessment shows the person to be an adult. That's now been updated. And the wording now is unless and until a case law compliant age assessment has been completed. So by definition, if you are challenging a local authority's age assessment, you're saying it's not case law compliant. And if there's any dispute, then until the final determination, they should be presumed to be a child as per the guidance. And the High Court in that case also said that the ACDS guidance will be relevant to whether the local authority has given cogent reasons for departing from the statutory guidance, which is otherwise final. I'm sure a lot of you have come across cases where a local authority has made a decision on age, which might not necessarily be a full age assessment. It might be a short form age assessment, or in whatever way it's inadequate. You then present further documentation that may have taken a long time to gather. And when you present that to the local authority by email or otherwise, they say, oh, we will consider it. It's been sent off for consideration, often by the National Fraud Office. But what does that mean? Does that mean they are conducting a fresh age assessment? Does that mean there is doubt? Have they already completely closed their minds to no evidence? And is that a bettering of their discretion to consider it? Well, the ACDS guidance is helpful on this and sets a threshold for when an old age assessment is superseded by that email that says we are considering this new evidence. So it's where you believe that a significantly different conclusion might be reached and that the child or young person may be notably older, then a new assessment should be undertaken. And so any indication from the local authority that they're reconsidering what they've done, whether or not judicial review is in the pipeline or whether or not there's a formal challenge, the guidance is clear. They will need to plan for suitable accommodation during that period. And yeah, that if that threshold has been met. So also in the guidance, once you secure the Section 20 accommodation, it's clear that the regulations apply to all children, regardless of their immigration status, nationality, or documentation. So if a child has been placed in Section 20 accommodation and then remains in care, they will then become a care leaver and eligible for support. So we want to make sure that they're in that accommodation as soon as an age dispute arises, so that they can then accrue the time and be eligible for support later on. If their immigration status is unresolved by the time they turn 18, that doesn't necessarily mean that they will no longer be eligible for support. And we have to look to Schedule 3 of the Nationality, Immigration and Asylum Act 2002, which states that a human rights assessment must be undertaken at that stage. So I know that our lovely marketing team are going to be sharing these slides. So this is just a little summary of what support is available for care leavers and highlights the timeframes that we're looking at. So the sooner we can get age disputed children into accommodation, the greater level of support they'll be guaranteed thereafter. And hopefully they won't be re-trafficked in the meantime. With that, I'll hand back to Kate. Thank you.
I'm going to take questions at the end, so do save them up if you have them. Thank you. So we're now going to turn to Grace Capel, who specialises in immigration, asylum and related public law. She's instructed in a diverse range of cases, and her expertise includes international protection, unlawful detention, and challenges involving identification and support of trafficking victims, which leaves her very well placed to talk to us about what support is available to trafficked children. So she's going to talk about the legal and policy framework, which will take up, could probably take up all of the afternoon, but we're pausing her to give us a quick overview, and if she has time, she's going to touch upon the illegal immigration bill.
I'm going to put a stopwatch on because I don't trust myself to keep to the 15 minutes. Okay, so for now, and subject to the public order exception, which my colleagues will address this afternoon, all victims of trafficking, including children, are entitled to receive support for their physical, psychological and social recovery. And Georgie has explained that this support also serves as an important protection against the risk of re-trafficking. This entitlement derives from Article 12 and 13 of the Council of Europe Convention on Action Against Trafficking in Human Beings, or ECAT. And Article 12 states, see up there, that each party shall adopt legislative or other measures as may be necessary to assist victims in their physical, psychological and social recovery. And that assistance must include at least a list of support at subsections A to F. For shorthand, I'll refer to that as recovery support. So unpacking this a little, Article 12 sets out a baseline minimum standard of recovery support which must be made available to all victims, whether they're adults or children, with the specific aim of assisting their recovery from their experiences of trafficking. It requires states to make arrangements to ensure that the baseline minimum standard of recovery support is available to all victims and the actual support provided to the victim in an individual case. Article 12 doesn't require states to set up completely brand new arrangements, but it does require that whatever those arrangements are, they're made bearing in mind the specific purpose of Article 12 to assist victims with their recovery, and they must ensure that the baseline minimum of support guaranteed by Article 12 is available to all victims. So if the state decides to rely upon existing arrangements, it must ask itself whether those arrangements ensure the baseline minimum assistance in Article 12 is available. And just very briefly, the effect of Article 13 ECAP as implemented in the UK is that victims are entitled to the recovery support in Article 12 during the period between the reasonable grounds and the conclusive grounds decision. That's known as the recovery period. An obligation to provide recovery needs support can also be derived from the operational duty under Article 4. Article 4 imposes a number of positive obligations on states, which are, for practical purposes, binding as a matter of domestic law by virtue of Section 6 of the Human Rights Act. Here we're concerned with the operational duty, which is a duty to take steps to protect individual victims of trafficking. And although there is no automatic read across from ECAT, the way in which the case law has developed shows that the content of the protection duty is to be derived from the provisions of ECAT. So, for example, in Children in Greece, the European Court of Human Rights stated that the positive obligations under Article 4 must be construed in light of ECAT. And in explaining the content of the operational duty, the court stated that this includes assisting victims with their physical, psychological, and social recovery. So, the language of ECAT. Looking at the domestic arrangements. Because ECAT's an unincorporated treaty, it's not directly effective under domestic law. However, in the UK, the obligations under Articles 10, 12 and 13 have been implemented by a variety of measures, including the national referral mechanism. It's clear from the UK's legislation and policy that the state body, which has overall responsibility for the arrangements for all victims in the UK, is the Secretary of State for the Home Department. Section 50A of the Modern Slavery Act requires the Secretary of State to secure that any necessary assistance and support is available to a potential victim, necessary being defined as necessary for the purpose of assisting the person in their recovery from any physical, psychological or social harm. Again, reflecting the language of ECAT. Section 49 requires the Secretary of State to issue guidance to public authorities about several matters, including the arrangements for providing assistance and support to potential victims. That guidance is the Modern Slavery Act statutory guidance, and it sets out the NRM arrangements that implement Articles 10, 12 and 13 ECAT. The Secretary of State has chosen to make different arrangements for the provision of recovery needs to support to adults than for children. And I'm going to suggest that the arrangements for adults ensure the baseline minimum of recovery support under Article 12, but the arrangements for children do not. The arrangements are described in the statutory guidance, and for adults we can see that the Secretary of State has consistently made contractual arrangements for the provision of recovery support to adults, current contract being the Modern Slavery Victim Care Contract with the Salvation Army as prime contractor. Importantly, what's provided through the MSVCC does not prevent victims from accessing other support that they are entitled to receive, although adjustments may be made if there is a duplication of support. Annex F to the statutory guidance sets out in a great deal of detail what support is available to adult victims and exactly how it may be accessed. All categories of support under Article 12 ECAT are included within the guidance. Adult victims also receive MSVCC financial support, which is directed at meeting their trafficking-related recovery needs, distinct from their essential living needs. And the most recent version of the Modern Slavery Act statutory guidance dated May 2023 underlines this by dividing financial payments under the MSVCC into the essential living needs component and the recovery rate. So a victim might not receive the essential living rate, for example, if they're receiving asylum support, but all victims are provided with the recovery rate. And that's an important part of ensuring that the arrangements meet the minimum requirements of Article 12. For children, the Secretary of State, through the statutory guidance, designates local authorities as the primary service provider for safeguarding and responding to the needs of a child victim. That's not controversial as far as it goes. However, the question is whether or not those arrangements on their own ensure the baseline minimum of support to child victims. Local authorities are not able to access MSVCC support for child victims, and they receive no central government funding specifically directed towards meeting the trafficking-related needs of child victims. When you look at the Modern Slavery Act statutory guidance, by comparison to Part 8 and Annex G for adults, the the statutory guidance provides very little direction to local authorities as to the arrangements specifically for meeting the trafficking recovery needs of child victims. And also striking is the absence of specific reference or provision for child victims who are not looked after by the local authority. The involvement of local authorities is in the provision of recovery support to child victims is a long-standing feature of the UK's arrangements. However, and importantly, there is simply no evidence that the Secretary of State has ever asked herself whether or not the Children Act framework ensures that baseline minimum support under Article 12 ECAP is available to all victims of trafficking. So just briefly looking at that framework, I don't have time to look at all of it. First of all, there is a obvious and significant gap in the arrangements for child victims who are not in the care of the local authority. I can't remember whether these are quite the most up-to-date statistics, but 5,000 child victims, the majority of which were British, were referred into the NRM, many of whom won't be, of course, in local authority care. So this is a really significant issue. Looking at Section 17 of the Children Act, this requires local authorities to safeguard and promote the welfare of children in need in their area by providing services for them and their families. However, this is a general duty, not a duty owed to a specific child, and is not individually enforceable. The local authority has powers to assist a child victim who is in need, but no duty. As Lord Hope put it in the case of Georgie Rea, Section 17(1) is concerned with general principles and is not designed to confer absolute rights on individuals. So Section 17 on its own doesn't provide the baseline minimum guarantee of the recovery support needs under Article 12. Two pieces of guidance, which I've listed up there, also touch on the position of children who are not looked after by local authorities. However, these guidance documents don't refer to the requirement under Article 12 to ensure that victims receive the minimum baseline recovery support during the recovery period, and also say nothing about the specific arrangements that must be made to ensure the baseline minimum guarantee of support under Article 12 ECAP. Turning then to the position of looked after children, even the specific duties that are owed to looked after children incorporate discretion and judgment with no baseline minimum guarantee of support for the specific aim of recovery. Section 21 expresses a duty shall provide accommodation, but subject to the local authority's judgment, who appears to them to require accommodation. See also Section 23, shall provide accommodation, but this is also subject to the local authority's judgment, who the local authority considers is likely to be seriously prejudiced. Under Section 24, a power, not a duty, if the local authority considers that. And I don't have time to go through all the provisions, but you can see similar discretion can be found under other provisions, Section 22, Section 22A. So as Lord Hope explained in Georgie Rea, where there is a discretion, a child doesn't have an absolute right to the provision of the services. However, child victims do have an absolute entitlement under ECAP to access a baseline minimum of recovery support directed at their physical, psychological and social recovery. To be clear, I'm not saying that there can be no discretion as to how support is provided to child victims. The point is that there's no discretion as to whether the baseline minimum recovery support is made available to them. So for looked after children and care leavers, the approach to the local authority's exercise of discretion is set out in more detail in the Care Planning Regulations 2010. These were amended in 2014 with the aim of bringing greater attention and focus to the particular needs of these children and enabling them to receive specialist support and care. The regulations do require local authorities to record if a looked after child is a potential victim of trafficking in the care plan, and this is carried through to the preparation of pathway plans for leaving care and in pathway plan reviews. However, the absence of any specific reference in the regulations or the associated statutory guidance to the requirement under Article 12 to provide the baseline minimum support creates a gap for child victims. And the care of unaccompanied trafficked children, which I believe we may have already touched on briefly, also does not state that the child has an absolute right to a baseline minimum guarantee of support, the kind in Article 12. directs local authorities to take particular account of trafficking needs, but doesn't provide specifics on what recovery needs the local authority is expected to meet and how these can be met. So this argument, the argument that the Secretary of State is in breach of her duties under Article 12 ECAT and Article 4 by failing to make arrangements that for the baseline minimum standard of recovery support for child victims, was the subject of a full hearing before Mr. Justice Lane last week. I was privileged to be the junior in the case, and I was led by Shush and Liu, our instructing solicitors, Willie Day. Unfortunately, I don't have the time to do justice to some of the other arguments that were, wonderfully put forward by Shush at the hearing. But we were extremely fortunate in that case to have witness evidence from ECPAT and an independent social worker to explain what the Secretary of State's failures actually mean in practice and how they affect child victims. So I think I'm maybe slightly running over, so I'm going to make a few very short points. For those not in local authority care, there's simply no guarantee of any support and a real risk that those victims are falling through the cracks. For looked after children, what they get is a matter of assessment and discretion without the safety net, as you have in the adult arrangements, to ensure the minimum guaranteed support under Article 12. For children in care, local authorities often don't recognise the need to identify and address needs arising from trafficking experiences separately, and in certain cases to provide trafficking-specific and specialised recovery support. Instead, often trafficked children receive the generic support that is provided to all unaccompanied children or migrant care leavers, with no differentiation based on their victim status. And one reason for this might be the lack of centralised funding, whereas the Secretary of State has created funding arrangements with local authorities to provide additional funding for unaccompanied asylum-seeking children or migrant care leavers in recognition of the fact that they may have needs requiring additional support. No such arrangements have been made for child victims of trafficking. I'll leave it there. Thank you.
Much Grace, and that was a whistle-stop tour through a huge amount of policy and legal framework, and it's extremely helpful for us to start to unpick how we might ensure protection are put in place. Particularly, I'm thinking of children that we see in the criminal jurisdiction where there are non-prosecution protections. The case comes to the end, but there's no support put in place, and they become re-trafficked, and it's often domestic trafficking, county lines, and they are re-trafficked. They come before the criminal justice system again, and there's a reluctance to review the prosecution on that second occasion, when in fact the state should have come in and with them being trafficked. So we need more people like Grace to come in and find ways to ensure the local authority puts in place the support they deserve. So we're now going to look at protecting children with special educational needs from trafficking, and they are particularly vulnerable, as Nicola and Ollie are going to explain. So Nicola is a leading equalities and discrimination law practitioner. She also specialises in public law and human rights. She has a broad practice from employment, education, community care to immigration and asylum. And so she's going to shine this expertise on this very important area, helped by Ollie, who has a broad claimant-focused public law and human rights practice. He is a rising star in many respects, but has also been recognised as such by the Legal 500, and specialises in community care, looking from age assessments, asylum support, welfare benefits to health and social care. And is known particularly for his expertise in special educational needs, but it's also his knowledge of British Sign Language, which I'm learning for the first time. So first to Nicola.
Thank you, Kate. Hello, everyone. And I also echo how lovely it is to see everyone in person and not be sat in a very messy study staring at my screen. I can pretend I have a tidy study. So Ollie and I are speaking about children and young persons with SEND, special educational needs and disabilities, and their increased risk of exploitation. But that's to do with us. Yeah, so we're going to be speaking about that, children with SEND, and also the interrelationship between exploitation and specifically exclusions, and how actually they drive each other. My takeaway, I would say, from my very short session, because I'm going to speak to you for only just over about 5 minutes, and then Ollie's going to take over and speak to you about key issues, is for you really to be aware, I expect you all are, to really be aware of the threshold that you need to meet under the relevant statutory provisions to recognise and put forward that your client or our clients meet the definition as children with SEND or young persons with SEND, or are as disabled young people, children. What I'm going to do is take you to the two specific reports, one from Just for Kids, and I see that we've got some Just for Kids law delegates here today, which is great. Another from the Human Trafficking Foundation, a report from them, and then an ongoing study that I'll tell you about that specifically speaks to trafficking and exploitation for children and young people, concerning children and young people with special education needs and disability. So what's the definition that you have to have in mind? The two relevant statutory sections are the Children and Families Act, Section 20, and the Equality Act, Section 6. And the threshold under the Children and Families Act is that when you are representing your client, does your client, your child or young person, have special educational needs if he or she has a learning difficulty or disability which calls for special educational support provision because they have either significant greater difficulty than the majority of those their age, or have a disability which prevents or hinders him or her from using mainstream education facilities without specialist help or equipment. So that's the definition under the Children and Families Act. And in terms of the Equality Act, it's whether your client, Section 6, has a physical or mental impairment which has a substantial and long-term negative effect on that person's ability to do normal daily activities. And substantial there refers to more than small or minor. So taking longer to get dressed or complete a daily task will mean that your client falls within that definition, long-term meaning 12 months or more. So the reports, the first one is the Just for Kids law report, and that, if you consider the time of that, that's the first one that was in August 2020, so just a few months after the start of lockdown, and the report made several key points. The first is that children who are outside of mainstream education, so obviously that means those with SEN are more likely to be hit in that respect, are more vulnerable to becoming the victims of childhood criminal exploitation, CCE. Children who've experienced exploitation will be more vulnerable to exclusion and may be disproportionately impacted by exclusion. Existing evidence and evidence from Just for Kids law casework suggests that some behaviour that leads to exclusion can be orchestrated by criminal actors as part of furthering the child's exploitation. And the recommendation was made that, with respect to statutory guidance, the Department for Education should include provisions that mitigate the risk that victims of exploitation will be excluded and protect the children most vulnerable to exploitation in the future. So that's specifically flagged up. And then what the report also set out was that we understand that behaviour resulting from exploitation will likely be concerning for schools, and that as a result, many schools have a zero tolerance approach to either. But of course, what that does is to disregard what the underlying causes may be, and to disregard that very often, almost inevitably, behaviour, breaches of behaviour codes and policies are actually due to other particular special educational needs or disabilities that haven't been recognised, or for which provision hasn't been provided, and so it leads to the behavioural breaches and then exposes the child to the zero tolerance approach. And so the report goes on, however, whilst that may be considered appropriate in cases where a child or young person has taken it upon themselves to engage in this activity without coercion, in cases of CTE, it furthers that young person's exploitation and punishes them for what is clearly a critical safeguarding issue. The report also highlighted, going back to that, and again, this ties in with the timing of it, that those risks are compounded as most children were not at that time, and then for many months after that, and in the second period at school because of the lockdown, the pandemic. And that widespread lack of protection that schools would have provided them meant those children were then at greater risk of experiencing exploitation during lockdown. And specifically, the report also set out that the lack of SEND report, so it's just doubling down more and more, layer upon layer of increasing the vulnerability of those children, meant that without that could lead to a spike in exclusions when schools reopened because children were not reintegrated and they were not supported effectively. And so more risk for those children of exploitation. The second report, this was by the Human Trafficking Foundation report April 22, and that was a report that followed on from 2 roundtable meetings, finding out direct case accounts, from finding out accounts and research and evidence from frontline workers and also practitioners. And there, what the report sets out was that, and again, a lot of this is actually no surprise, but it still needs to be set out, and this is all evidence underlining that of course, where you have multi-agency collaboration, that is going to lead to better practice and better protection and support for the individual. Working in silos is going to mean that children fall through the gaps, and then as a result of that become targets for exploiters. The other key point that was highlighted in that report is the boundary of childhood and adulthood, resulting in this cliff edge for victims. And so the lack of commitment to transitional safeguarding resulted in the support then fragmenting as they reach the age of 18. A shocking statistic that child trafficking is steadily rising, accounting for 43% of all NRM referrals in 2021. And the reason for this is criminal exploitation of primarily British children. I've raised also there these issues of systemic racism, and that ties into a point then is also made in the report about how that links up with undiagnosed and unsupported special educational needs. And then the next page. So the report then went on to say the correlation between school exclusions and child criminal exploitation is well documented, and Ollie is saying more on some of the issues there that arise. Once you're excluded, you're an easy target. So as I say, none of this is actually surprising, but this provides more evidence of it. Pupil referral units have far less supervision. And actually coming back again to exclusions are a key root of problems, should not be used where children are vulnerable to exploitation. And in fact, suspension exclusion must always trigger a vulnerability assessment. And then what the report also says, and this is where the issue about racism comes into the increased risk as well, that practitioners reported concern for the disproportionate number of boys from Black and ethnic minority backgrounds excluded from school as a result of relatively low-level behavioural issues stemming often from underlying undiagnosed conditions such as autism or attention deficit hyperactivity disorder. And then finally, specifically on children and young people's SEND, the study that is the internal trafficking and exploitation of children and young people's SEND for England and Wales. That's due to conclude in August this year. And that is a study to identify gaps in law, policy, guidance and evidence to support the better protection of children and young people with SEND. It's going to be examining practice responses from the perspectives of practitioners, parents, carers, children and young people. It's going to be consulting with strategic and frontline multi-agency practitioners and developing specific outputs. And what that specifically at present, what that has already set out is that children and young people with SEND not only have the vulnerabilities as children, but they have the additional vulnerabilities due to impairments and issues including high levels of school exclusion, bullying and social isolation. Those increased risks and vulnerabilities are often not well understood by multi-agency services, which again goes back to this point of the need to have multi-agency cooperation. Responses and requirements under the MSA rarely recognise these additional vulnerabilities. And then, I mean, it's just also tragic that the group of children are often invisible to agencies, and signs and indicators of trafficking harm can be missed or misattributed. So I'm sure that everyone in this room is entirely alert to all of this, and I imagine that none of it comes as a surprise, but I think because it is also tragic, and these particular clients of ours need all the help that we can provide to them, and it's so crucial that we all work together in providing that help. This can't really be highlighted enough. So those are my points. I'm going to hand over to Mr. Persey now. Thank you very much.
Thank you very much, Nicola. So I'm going to be building upon what Nicola has already said. I'm conscious of the time, so this is going to be a whistle-stop tour in 5 minutes. So Nicola's already spoken about disproportionalities in exclusion rates. I want to briefly highlight what was unfortunately removed from the 2022 edition of the Statutory Guidance on Permanent Exclusions, which was specific reference to the disproportionalities of children with SEN, and also certain racial groups are overrepresented. This data is being collected, though, by the Secretary of State through the annual school census. So up-to-date data is available, and you can use it in representations to school governors and in independent review panel hearings that are reviewing a school exclusion. One good thing that came about of the new guidance, well, there were 2 new guidance documents that came out in 2022, one on permanent exclusions and one on behaviour. And in the behaviour guidance, it improved the monitoring requirements on schools and academies in relation to exclusionary practices, such as use of isolation rooms, and the protected characteristics of those, including SEN, whether they're on a SEN register or have disability, need to be scrutinised. So when you're representing in independent review panels or governors, get that data, ask for that data to show whether there's a systemic problem in the school about overrepresentation of children with special educational needs who are being sanctioned either through permanent exclusion or similar initiatives. Grace has already referred to the protection duty under Article 4 ECHR. I'm not going to cover it in much more detail. You'll have the slides. The point being, it's a frontline duty too, and that is not being integrated into the school exclusions process. The protection duty does what it says on the tin, but doesn't actually get integrated in the school exclusion process. There is no reference to it in the statutory guidance. There's no reference to the Modern Slavery Act, despite Just for Kids Law's ardent campaigning, no reference to child criminal exploitation in the school exclusion statutory guidance. That's just a bit more building upon what Grace already said about the ECHR protection duty. TDT is a key authority. So drawing together the threads that Nicola has already highlighted, there are fundamentally, and I'm sorry, there are local authorities here, but I'm going to be rude to your face. There is generally poor systems in place for identification of children and young people with special educational needs, and part of that is budgetary constraint from national government. But the Children and Families Act 2014 imposed a positive duty to use all functions on a local authority to identify special educational needs. Section 22 of the Children and Families Act provides that all functions of a local authority must be used with a view to identify children and young people who may have, not necessarily have, special educational needs or disabilities in their area. That duty is completely unincorporated by local authorities. And it means that there is a fundamental problem in identifying special educational needs, because it is left to parents and schools to make referrals for education healthcare needs assessments, which means that many of the children that have SEN do not get referred in. And that twins with the point that Nicola raised around race and SEN and the intersectionality of the two. There is extensive evidence of essentially profiling of Black children, that they are naughty and don't have, or bad, rather than having special educational needs that are undiagnosed. So there's a racist gatekeeping of special educational provision and access to the assessment process. So the next point is the lack of sort of local authorities being taken out of the education system by academisation, which, so schools, as listed lower down on my bullet points, are not first responders. So they cannot refer into the national referral mechanism. An academy takes a school, the academisation of a school reduces the oversight and involvement of local authorities that are first responders into the sort of identification process for victims of modern slavery or potential victims of modern slavery. I've already mentioned the problems with the Article 4 duty and Modern Slavery Act duties not being integrated into statute guidance. That is truly terrible because, as you can see, zero tolerance policies could be really screw over kids. So just to work through how that works, a child or young person may have drugs planted on them. They go to school, they get permanently excluded, zero tolerance. They then end up in a pupil referral unit where there's less supervision, they don't necessarily attend frequently, and they are much more susceptible to county lines. And that's a pernicious cycle that zero tolerance policies really are a crucial cause of, because there's not the flexibility to understand that that could have been, for example, as a result of duress or coercion, that initial incident happened. Zero tolerance done. And twinned with the lack of integration of modern slavery duties, that's just a disaster and an opportunity for traffickers. The final point is one that I've already mentioned, and I'm going to add a further one onto it. Pupil referral units and alternative provision are fundamentally unsafe. There's less supervision, which means that children and young people can go missing and do go missing. They're also effectively written off when they go into PRUs. You only have to look at the attainment records of children that go into PRUs to show that their educational prospects go off a cliff. The school to prison pipeline, of which PRUs play an important role, is well documented, and there is a racist and ableist dimension to that is extremely clear. The final point is there's basically no legal aid. For the education legal aid provider base is really struggling, and LASPO removed exclusions representation from the scope of legal aid. That means families are going to independent review panels, which are meant to apply judicial review principles, unrepresented. That means that these fundamental points, the best safe, are not being made because they're complex legal arguments. And the supposed safeguard against arbitrary decision-making by schools in exclusions is the independent review panels are largely lay panels without legal expertise, apparently applying judicial review principles without legal representation before them. Things get missed and important points do not go argued, which has the consequence that they are not an effective safeguard against arbitrary exclusion by schools. And that is the end of my presentation.
Well, that's going to be a hard act to follow. But thank you so much, Ollie. And I think it is worth, and Nicola, it's worth mentioning that we see this cycle continuing into the criminal justice system, where it's estimated that 92% of children are undiagnosed when they enter the justice system. So those with speech, language and communication needs haven't yet had them identified by the time they get into the criminal justice system, and has been the AV described exclusion from school or pupil referral units are all incubators of of the journey into the criminal justice system. So we really need to identify these children far earlier on so that we can get their needs met and prevent them from being excluded and kept in mainstream education. So finally, we are going to turn back. We're going to be joined by Nicola again, but Nadia O'Mara is also going to speak to us about how we seek redress. And this is a really important area and shouldn't be overlooked, because we are really going to support practice change and systemic change if we identify where needs have not been met, where duties have not been followed. And so it's really important to bring damages claim for maladministration and delay in meeting the rights of children's needs. And so Nicola again is going to join us, but she's joined by Nadia, who is a relatively recent addition to Chambers. She has a busy judicial review practice and again has multidisciplinary expertise from immigration and community care to age assessments and education rules. So first,
Nadia, and I'm going to be at the end so that you get a little.
Sorry, yeah. Thank you. So thank you, Kate, and thanks everyone. As has already been said, I'm splitting this presentation with wonderful Nicola, who you've already heard from. We are going to talk about Human Rights Act damages claims, particularly in the areas of delay and maladministration, but in the context of victims of trafficking, and so specifically looking at delays between the positive reasonable grounds stage and the conclusive grounds stage, which many of you will be aware is afflicted with endemic delays. I'm first of all going to try and whiz through the legal framework, much of which has already very competently been covered by Grace, so I will go very quickly and forgive me of some overlap. I'll also then look at a couple of examples of reported cases to kind of give you an idea of what we're looking at in damages cases. And then I'll hand over to Nicola, who's going to share her wisdom on tips and tricks in running this kind of case. So then turning to the trafficking framework, as I've already mentioned, you have heard most of this from Grace already, so I will speed through. But of course, we have the primary mechanism under ECAS. In terms of Chapter 3 and the various measures there, I would in this context just draw attention in particular to Articles 10 on identification and Article 12 on assistance. The only point I would raise in addition or to emphasise what Grace already has said about Article 12 is the fact that it is an absolute duty. Looking again then at Article 10 in terms of the identification obligation, this is also an absolute duty, and it's an obligation to both identify victims of trafficking and an obligation not to remove potential victims until the identification process is complete. Then we have in terms of the complicated mechanisms by which we get ECAT into domestic law, I'll just whiz through. But safe to say, Article 4 ECHR, a number of Strasbourg judgments, and Section 6 of the HRA, and then we get the positive obligations under Article 4, which, as held in by Strasbourg in the case of Children, must be construed in line with ECAT obligations. Looking then at what delay really looks like in this context. So in terms of the legal obligation here, the Strasbourg court held a requirement of promptness and reasonable expedition to be implicit in its obligation under Article 4 to investigate situations of potential trafficking. There was a previous attempt to challenge the delays which we have seen in the decision-making process between positive and conclusive grounds a number of years ago. But again, what we saw was that those decisions still need to be made within a reasonable time. But in that case, it was concluded that in effect that the Secretary of State had it all in hand, or it would shortly be in hand. But that has not transpired. The latest quarterly statistics state that the average time from referral to a conclusive grounds decision across the competent authorities was 566 days, and in many cases it is much longer. And when you consider, and there obviously is some variance, but you do tend to see positive, you tend to see the reasonable grounds decisions being made loosely within the set objective of 5 days. There's sometimes a delay, but then when you look at the 566 days set against that, it really is quite shocking. Fast forwarding to last year and the Court of Appeal in EOG and KTT, here you start to see that the court describing the extraordinary length of time which it now takes for the Secretary of State to make these decisions. The final case referred to on this slide, Nicola will speak to in a bit more detail, but certainly the experience that you've had so far in that case, as far as I understand it, is that there was no decision forthcoming, and then the second you threaten judicial review or you issue, suddenly a conclusive grounds decision appears. In terms of just briefly the legal framework under the HRA and case law that we're talking about here, these are provided for in Section 8 of the HRA, which gives effect to Article 41 of the Convention on Just Satisfaction. The leading case still, which many of you will be familiar with on the specific issue of delay and maladministration, is Aubrey-Johnson. And I, in the interest of time, won't read all of that out, but you do have the slides. Much later, the Court of Appeal in Said helpfully distilled some of those principles as relevant to what we're talking about today, though again, these cases were concerned with Article 8. But in the context of delay and maladministration, the general mood of the court in terms of awarding damages is that there is a sort of disinclination, first of all, to recognise that mere maladministration does engage Article 8 in that context, but that what you are needing to show is that there have been really serious consequences as a result of that breach. Even where you are able to show such consequences, then still you may be seeing that the damage awards are going to be modest. However, and though I don't quite see how these two pair together, but they should not be minimal, as this would undermine the respect for convention rights. But where then you do cross a line, and in the last paragraph that you see there at 138, where you do cross a line into really what's manifestly excessive delay, which I think there can be no question that what we see in terms of the delay and conclusive grounds decision certainly is that what you can be looking for really is an award significantly more than compensation. Turning then to examples of awards under Article 4 that have been seen, I think this may have been one of the first cases on Article 4 damages, the case of 000. And this was a case which concerned the police failure to investigate traffickers rather than to protect trafficking victims. But what you'll see there is that the award at that time was really quite low, so only 5,000 to each claimant. But then when we look at the Strasbourg precedents, things are a bit higher. But the point that I would raise, and I'll just whiz through these, is that it's quite important to be looking at really what the specific facts of the case are. And so in the leading case of Ransev, it was quite a significant award of 40,000, but in that case you're talking about death in Article 2 breaches in addition to Article 4. Same in terms of Ciliadine and France, also splitting and looking out between pecuniary and non-pecuniary losses. Just a few more examples there, and there is a variety, though none of them are extremely high, but the point I would pick up there is that when the court, in these cases anyway, when the court conceives of the breaches as more purely procedural, the awards tended to be lower. But then, and many of you will be familiar with the quite recent case of VCL and AN. I won't go into the facts there, but I would draw attention to the final bullet, which in effect acknowledged the suffering and distress that had been experienced, but quite crucially suggested that these breaches still were essentially procedural in nature. And then the court went on to award €25,000 to each claimant for non-pecuniary damages. And that, well, I thought I had another slide, but I didn't. But yes, that was more or less what I was going to say. 1 second. But yeah, anyway, just drawing all of that together, I think there's a lot of help that we can sort of seek from the Article 8 case law around delay and maladministration. There's really no reason why those same principles shouldn't be read over into the Article 4 context. And when you look at the sort of the life impacts that those breaches have, and that recent Strasbourg case law, I think there are good arguments for seeking quite high awards in damages, bearing in mind the limitations. Thank you.
Right, so I'm back. These are my top 10 tips, but I really welcome all tips that any of you have. Please do let me know. I'm always interested in learning more and from others' experience. So top 10, first 3, flag early. So as soon as you are taking instructions from your client, you think you might have a damages claim, or you're exploring more whether you have a damages claim, get those instructions on the witness statement. You'll be updating with witness statements, and obviously the more contemporaneous in time your evidence is, the stronger the quality of that evidence, the reliability and credibility of it. And it's better that way round than coming a few months down the line and then thinking, well, maybe we should run a damages claim. So have your mind open to it. You might have other witnesses you want to get evidence from to support that. You might need expert evidence, GP reports, GP records. All of this takes so long, school reports, but have in mind the importance of that, of your evidence gathering, and also make your subject access requests and repeat those requests, because I've had direct experience of comparing different subject access request documents and seeing actually that they had been changed in parts, and it was only because we had repeatedly asked and were provided with supposedly the same documentation that we noticed these differences. So be very alert to that. Flag early in pre-action and pre-action correspondence. Don't treat it as an afterthought, because I think very often it can be treated as an afterthought. It can be pleaded as an afterthought, which you don't want, because you don't want the summary grounds. Obviously, I'm talking very much from the claimant perspective here, but I mean, in terms of it's in both parties' interest to flag up the issues as clearly as possible, so they can also be responded to in the same way. And press on disclosure. Whenever I've spoken on disclosure, I haven't been able to highlight enough how important that is. Disclosure continuing right up to the hearing and during the hearing. You just don't know what's going to crop up, and it can just change a case within the space of 24 hours. So be really alert to that. I say they're relevant to liability, but also obviously, depending on what you find in your disclosure, you might, by reason of those discoveries, then have a stronger claim on your aggravated damages or exemplary damages, so that there's oppressive behaviour by the state. So be alert to that, press on that. Compare with what has been disclosed previously. Obviously, in judicial review proceedings, really exploit the duty of candour and pressing on that. And when you are provided with some answers, don't just simply accept that. Press on. Question redactions. I see more and more chunks of documents redacted. And when you do, whether it's through further correspondence or making an application, very often, in my experience, redactions aren't actually properly redacted. Yeah, well, I was going to say also what I've had recently, which is very interesting, is that defendants have waived privilege by reason, as a sort of tangentially from disclosure. They've waived privilege by reason of what they've disclosed. So again, be alert to that and pressing on that. Negotiation. Use all opportunities throughout as you go. Pre-litigation, and then during litigation in the lead up to the hearing, directly before the hearing, and don't be put off. Keep going back on that. Standard practice. I mean, it's just ridiculously low. I might be wrong in my experience. My experience is that there just isn't any genuine, in negotiation, there doesn't appear to be any genuine attempt to at least start at something that resembles a reasonable offer. So don't be put off by that, because in that same experience, I've just seen an offer double from the first stage to the next. Be aware of timescales. Now, I have a lot of clients who completely understandably, and of course this is going to be more so when you're dealing with children and young people and their vulnerability, they don't want to be tied up in litigation for however, and of course a year in a young person's life just feels like an eternity. So I think, and that in turn has an impact in there being an increased pressure to accept a lower amount, which your defendant is likely to know as well. So I think if you sort of try and do a bit of groundwork, maybe your client will be able to just see that waiting a little bit longer, you might get some more compensation for that client. And then in the same way, anticipate obtaining updating reports, reasonable adjustments. Our clients almost inevitably will benefit and will need reasonable adjustments, and don't think that that's just for the hearing, but also think of reasonable adjustments in the lead up to the hearing. The Equal Treatment Bench Book is a really good source. So if you need more time, take more time, don't be pressurized. If you need whatever in terms of taking instructions and communicating, then flag those up and be aware of them. Something else I wanted to say on a final top tips. So as claimant representatives, we obviously have the disadvantage of not knowing what is going on the next case and the next case. We just don't know because it's very rare that these cases are reported. They're generally settled. Whereas defendants, be they local authorities or government departments, they have the benefit of this bank of how they're settling. So that's why I say be very aware of what is reported and what we know and what goes on behind closed doors. And to the extent that you can, exchange information with colleagues, build a bank of settlement figures, and use that to come back and inform your negotiation position. And then in terms of actually valuing, the Judicial College Guidelines is the assessment for general damages is a good starting point. It's a very good starting point in some respects on psychiatric injury and psychological injury, and certainly worth using, depending on which way you want to use it. Either if you want much more, then it's just a sort of good starting point, or if you think actually this is quite a decent amount, then obviously say this is more than a starting point. Vento damages are very helpful from discrimination claims, because on a vento claim, on a discrimination claim, a one-off act of discrimination will bring you within that low band of between 1,000 and 11,000. This is for claims issued after April this year. And I think it's so important when you're looking at the Human Rights Act and Section 8 and what that's about, affording just satisfaction. It's all very well having a declaration, but our clients don't have money, they don't have very much money at all, and they're on the breadline. So £1,000 or £5,000 or £10,000 will make an enormous difference. So a declaration is not just satisfaction. And that's why I think it's so important to push the damages claims. Hold your nerve. I was thinking, how should I end my 10 tips? And I went for just hold your nerve. They will, in my experience again, and I am very much coming to this from the claimant point of view, the first offer, if you get it, is ridiculously low, and you just have to hold your nerve, and you would be surprised not only what Treasury approval you can get, but actually if, when needed, that suddenly people can get into action and they can get instructions, even though they said before they need several months for it. But I'm very, yes, I'm not going to say any more, but those are my top tips. And if you have any, please do let me know. Come and speak to me or email me. I really, really would value knowing yours. Thank you very much.
Well, wow, that's a huge amount of really helpful information, guidance, analysis of the information around bringing damages and making those claims. We have really run out of time for questions. Has anybody got a burning question? If not, you have the opportunity to interrogate this amazing panel of speakers while they were also getting a cup of tea downstairs. So again, we're delighted to all have you here in person, in real life. Make the most of speaking to colleagues and other people doing similar areas of work, but also pick the brains of these very distinguished panelists. Thank them all very much for sharing their top tips and their thoughts this afternoon and join us downstairs. So thank you again.
Thank you very much, Gemma. Thank you all. Thank you all for returning to our Children's Rights Conference. My name's Gráinne Mellon. I'm chairing this next very interesting, very erudite panel on the criminalisation and treatment of trafficked children. We have a really brilliant lineup of speakers and of topics, and I'm going to take you through who our speakers are and what we'll be covering shortly. Just some preliminary points. This hearing is being recorded, as you know, from earlier this afternoon, and it will be uploaded to YouTube. So to those of you who don't want to take extensive notes, that is an option available to you. And as you all know, when we finish around 5:30, we are going to have post-conference food and drinks. We would love you to stay for that. But in the meantime, back to the final event. We have 3 sets of presentations this afternoon, all on the theme of criminalisation and treatment of trafficked children. We will be touching on offences and decisions to prosecute under the Nationality and Borders Act 2022, criminalisation of children and the remand of children into adult prisons, including in age dispute cases, and then missing asylum-seeking children and Home Office policy. So in terms of who we have speaking today, many of you will know them anyway, but on our first topic, which is offences and decisions to prosecute under the Nationality and Borders Act, we have Sonali, Naik, KC and Gemma Loughran. Sonali is a silk here in Garden Court who practices across the board in immigration law. She will be known to many of you. A CV that's too long. I'm cutting the CVs right down. Trust me that they're all very experienced. I think she's now known mainly as Mrs. Rwanda, so that may well say it all. And Gemma is also a member of our immigration team, particularly well known for her expertise in trafficking cases and a contributing author to McDonald's chapter on trafficking. So they will be dealing with our first topic, which is offences to prosecute under the 2022 Act. We are then going to hear from Jen and Maria, again, who you may know. Jen is a practitioner in our public and crime teams. She's a former head of strategic litigation at Just for Kids Law. And Maria is again in our public and community care law teams, working a lot with migrant children and families, and again, particularly well known for her trafficking work, publishing and working extensively in that field. And then last but not least, in the front row, awaiting their seats, will be our final contributors. And we have three final speakers on missing asylum-seeking children and Home Office policy, touching in particular on recent litigation in the field. Amanda Weston KC, again, will be known to many of you. She is a public law silk here in Garden Court, working across the board, public law, immigration law, and also children and family law. And she's involved again in a number of, he's currently working on a number of cases, including with the Equality and Human Rights Commission. Polly Jackman, many of you will know, is the women's right lead at Good Law Practice and has experience working with campaigning groups and influencing public policy, has a background in human rights and family law, which influences her, no doubt, in that role. And last but not least, Caroline Willow, who is from Article 39, registered social worker, former head of Gráinne, which we all remember, the Children's Rights Alliance for England, and worked extensively on children in residential care, physical restraint of children, and has recently coordinated 2 major submissions to the UNCRC. So I know you'll agree that's a brilliant, fascinating panel and a really wide-ranging debate. So please keep a note of any questions that you have. We'll come back to you if that's okay at the end. And we're going to start with Sonali and Gemma.
Okay, thanks very much. So, just pressing the button. Pressing shift. Great. Okay, thank you. So I'm going to talk about decisions to prosecute under the new offences under the Nationality and Borders Act 2022. And thank you to Jen for assisting with the slides, because it reflects a case, particularly, or some of it reflects a case that we did together this year. So, as you can see under the new, the new Act, it's not, let's say, new anymore, but what was introduced into the Nationality and Borders Act was were two very significant offences under section 24 and 25 of the, amending section 24 and 25 of the Immigration Act, assisting unlawful migration, which is now not confined to the question of illegal entry, but also the question of arrival. So this particular provision came into effect from the 28th of June last year, and was a response to the Court of Appeal Criminal Division judgments in Kakai and Amadi in relation to illegal entry and how people could run their cases in respect of that defence. And so, in order to get around those defences, what the new Act introduced was new section 25 of the Immigration Act 71, which was assisting unlawful immigration to a member state or the UK. And as you can see, it sets out the terms of the offence there. A person commits an offence if he doesn't facilitate the commission of a breach or attempt to breach of immigration law, and then knows or has reasonable cause for believing that the Act facilitates that commission, knows or has reasonable cause for believing that the individual is not a national of the UK. But the significant change in relation to this provision is the definition of immigration law, and it which identifies the persons who are not nationals of the UK and in respect to their entitlement to enter or arrive in the UK or transit or be in the state. And so this concept of illegal arrival is a new one, and was the one that is so pernicious in terms of the way it impacts on asylum seekers. Obviously, we'll talk about asylum seeking children, but particularly in the context of age disputed minors, which is where it really bites in this context. Section 24D1, this new offence, which identifies that a person who requires entry clearance under the immigration rules and knowingly arrives in the UK without a valid entry clearance commits an offence. So this was the focus of the case that I did with Jen's assistants and others in chambers, Ali Bandagani and Raza Halim, which resulted in a preparatory ruling by Mr. Justice Kavanaugh in the case of Mohammed and others, which was ultimately unsuccessfully appealed to the Court of Appeal. So I just tell you, so I know we haven't got a huge amount of time, but it's really important to identify that the factual basis for these prosecutions were there were, I think, 5 defendants. They were all Sudanese nationals. They all were travelling on a rib, a small boat across the channel, which is set off from France. Each boat had other migrant passengers on it, and each boat was intercepted or rescued in UK territorial waters. And then each defendant was taken off the boat and escorted to the approved area in the port of Dover, i.e. before arrival. And then before entry. And then each person claimed asylum when they landed. And unsurprisingly, none of the defendants had a visa or entry clearance, because obviously if they did, they wouldn't be arriving like that. Those things are so obvious to us. We had to unsuccessfully run the argument in the Crown Court in Canterbury and then in the Court of Appeal that nobody can get a visa for this purpose. That was sort of news in some way to the Court of Appeal, but we still had to go through those processes and we couldn't possibly get a visa, and therefore we want to be able to run some kind of defence based on the fact that we can't get a visa. But in short, we were told we didn't have a defence to the offences. These are effectively strict liability offences, which is something that is not normally how we would interpret criminal law in this way, that every person, in theory, every person who arrives in this manner could be prosecuted. So the saving grace, or the saving grace as it is the way in which the court interpreted it, was to rely on the CPS prosecution, Crown prosecution guidance. So who is actually being prosecuted? So the statistics on the numbers of people who are being prosecuted is that they're very, very small numbers of people who are actually being prosecuted. in the significantly less than 1%. I'll get those numbers for you, and that was the way in which the Crown got around the sort of pernicious impact of this provision. The Crown Prosecution Service considers each case and determines whether it would be in the public interest to charge and proceed to trial, and there's a very small number. They say, this is like my client, in many cases in which the individual is believed to have been piloting the boat, it is more likely, well, certain, that he'll be charged with an offence under 24D1, which is the illegal arrival, or section 25, which is the facilitation. The section 25 is obviously the more serious offence, and there will be other circumstances where they might prosecute somebody for being the organiser of a trafficking operation or so on. One of the difficulties though with this was in fact sort of exemplified by my client's circumstances, which was that he was being prosecuted under 24D1, something he had effectively no defence to, effectively strict liability, because they thought he was actually a facilitator, but they couldn't prosecute him for that because they didn't have enough evidence. So he's caught in the sort of between a rock and a hard place, because he hasn't got a defence. He's prosecuted for something for those reasons, and they can't prosecute him for section 25, because they don't have enough evidence. The reason that obviously it's relevant for all asylum seekers, but for those who get caught in this trap, is that in particular, the CPS guidance is silent on age disputed minors. So although that wasn't my client, he was a young person, but he wasn't a young man, but he wasn't a minor. But there are cases, and I think you might hear about a little bit more from Jen, where if the guidance is silent on age disputed minors and you have someone who's being prosecuted, there's no guarantee the prosecution will be stayed pending the outcome of the resolution of the age dispute through the local authority or whomever. And then you can make representations maybe and initially review the decision to refuse to stay the prosecution if you are refused. But it's really unclear in either of those circumstances, if you properly await the outcome of the age assessment, whether, and if it goes against you, whether you'll get the credit for your, in respect of your guilty plea and sentence if you plead later on. I mean, the same is sort of true of Mr. Aldor, who was in the Mohammed case, although he wasn't dealing with an age dispute, he was dealing with the legal question of whether he had a defence. And ultimately, he didn't get a significant credit for that, because the delay was part of the preparatory hearing that took 6 or 7 months in the Crown Court and then in the Court of Appeal. And the likely sentences are, and this is the seriously worrying part, if you have an age disputed minor who's then presented with these alternatives, which is that in the sentencing remarks of the resident judge in Canterbury, that's His Honour Judge James, he said, because of the public concern about channel crossings, even though most of the persons who have been prosecuted are, it says most, I'd say all, but let's see if there's an exception, will be seeking asylum. The sort of general sentence will be 12 months after trial. And of course, we know what that means is that then you're liable to automatic deportation provisions under section 32 of the UK Borders Act. And although, of course, if you raise an asylum claim and all the claimants who we've identified in those in the preparatory ruling are all Sudanese, are all likely to get refugee status or humanitarian protection, and indeed almost everybody who's coming across on small boats is likely to get asylum. Just being in the auto deport context just raises the sort of stakes a little bit in terms of policy, in terms of potentially who could be earmarked for being sent to Rwanda should that ever happen, or any other third country. There's so many problems about hitting that policy threshold of 12 months that there's been a lot of pressure on people to plead earlier, or at least try to achieve a sentence of under 12 months rather than waiting for trial. And some of the Canterbury juries are acquitting, even though theoretically there's no defence of that. Or you may have defences of necessity, or other people just running their cases on the particular facts that they have. But there's a pressure, I'm sure, on everybody to plead, and that's the advice that they will be getting. To avoid getting a more than 12-month sentence. But the usual sentence would be immediate custody, although you can see the substantial mitigation if they stay in the magistrate's court. But obviously the other significant point here is about whether there's obviously compatibility with the Refugee Convention. That was the point we tried to run in the Court of Appeal and in the Crown Court. Ultimate as to whether it's an Article 31 penalty in terms of, so therefore that should be the basis of a defence. There was no expansion in the 2022 Act of Section 31, the 99 Act, which made provision for statutory defences, which made our life rather difficult. I mean, I do think there's a potential for challenging that, because the list in Section 31 can be amended by statutory instruments. So in theory, challenge the Secretary of State for the Home Department's failure to amend the list. And I do think that is one way we could think about it. But Mr. Justice Kavanaugh, in his the original lower court judgment, I'd said there's no need to ensure that you can have any other kind of way to make sure the UK complies with its international obligations, and identify a way in which there is a new statutory defence, because there's a different mechanism for giving effect to the UK's obligations, international obligations under the Refugee Convention, and that is done by means of the guidance given to prosecutors, which is what we were looking at a moment ago. And so he says that the mechanism of prosecutorial discretion not to prosecute, coupled with the backstop of an abusive process jurisdiction, is sufficient to comply with the UK's obligations. And that's what he effectively is saying. And the Court of Appeal approved his approach, and effectively and importantly said that the effect of the immigration rules, which is that a visa national requires a visa and entry clearance before arrival, even though they can't get one, is not a basis upon which we could argue that there was defence in law or any other form of incompatibility with the Refugee Convention. So, and indeed, Section 30, and the really important part, sorry, I know I'm probably running slightly over time, but the really important part of the Nationality and Borders Act, Section 37, is that a refugee is not taken to have been coming directly from a country if they stopped in another country outside the UK, unless they could show that they could not have reasonably be expected to sought protection under the Refugee Convention in that country. It's because of Section 37 of the 2022 Act that we were found not to have a defence, found not to have for there to be any incompatibility. And that is really, that was the intention of Parliament in the statutory framework. And so then you get that, and so in practical terms, you end up having to make representations to the CPS to try to persuade them not to prosecute on the basis of that you are coming directly, and then they become the arbiter of whether the UK is complying with their international obligations or not, which is a strange sort of place to be. We did try to argue about the relevance of the Human Rights Act. The Kavanaugh Court, i.e. the Canterbury Crown Court, declined to express a view because the Crown Court hasn't got jurisdiction to make a declaration of incompatibility. And I think if somebody were going forwards now to either judicially review the CPS guidance or wanting to argue that the prosecution was incompatible or discriminatory in relation to Articles 6 and maybe 7 and 14, potentially those arguments could be raised. We didn't pursue those ultimately in the end on this particular client's case. And Aldor, who was the case that linked with Mohammed, he ultimately received an 8-month sentence. And notably, the sentencing judge himself said, some people think you shouldn't be prosecuted for this, but I think I have to apply the law. So that's quite compelling, I think, in terms of what some judges certainly think is going on. I'll just reference back to the prosecutorial discretion, which I've already touched on. I think we're running out of time. And also back to referencing the point in the CPS guidance about prosecutors having to have regard to Article 31 when considering the public interest stage. And the final point, as we say, as I mentioned earlier, the backstop is a further backstop is jurisdiction to stay the proceedings if the if the judge takes the view that Article 30, in light of Article 31, it would be an abusive process for the case to proceed to trial. So those are effectively the mechanisms to challenge such decisions to prosecute. And then you overlay that with the difficulties of representing an individual, a child, or an age-disputed, children, I think in the guidance won't be prosecuted, but age-disputed minors may well be. And so that is, I think, the next stage of any challenge. So thank you very much. Sorry, I've definitely overrun, but I think that's good. Thank you.
Thank you, Sonali, for those reflections on your own case of Mohammed in the Court of Appeal and identifying future options for litigation. If anyone does have anyone who's subject to a decision to prosecute, whether a trafficking victim or an age-disputed child, it'd be wonderful to hear from you in the Q&A. But otherwise, we're going to now hear from Gemma, who's also talking about changes introduced by the Nationality and Borders Act, and this time it's public order disqualification decision.
So yeah, that's right. I'm going to be talking about disqualification from protection for victims of trafficking, which was also introduced by the Nationality and Borders Act. I'm also going to be referring to the modern slavery statutory guidance, but I'm afraid a new version was issued at some point last night after I'd done my slides. So all of the parts that I mentioned are still in there. However, the numbering is slightly off. So I'll amend the slides before they go out to you, but just bear that in mind, not to trust the YouTube video on that. Okay, so the part of the Nationality and Borders Act, which is key here, is section 63, and it provides that a competent authority may, so it's important it's a may, not a must, determine that a recipient of a positive reasonable grounds decision can be disqualified from protection if they're satisfied that a person is a threat to public order or is claimed to be a victim of slavery or human trafficking in bad faith. And that basically means that the person is no longer entitled to anti-trafficking specific support, the grant of leave of claim, the reasonable grounds decision doesn't act as a barrier to removal, and the competent authority is no longer required to make a conclusive decision. So basically all the things you heard about earlier on from Grace, disqualified from that basically. We can deal with bad faith quite quickly because there's an exemption for children. So that doesn't apply, that part of it. Then returning back to section 63.3, there's a list of the circumstances where someone might be considered as a threat to public order. And they might be the sort of things you expect: terrorism, risks to national security, but I just want to point out 63F, and that's if the person is a foreign criminal within the meaning of the UK Borders Act. Now, as I'm sure many of you know, the definition of foreign criminal is a person who's not a British citizen, convicted in a court of an offence, which they're sentenced to imprisonment of at least 12 months, or for an offence specified in the 2002 Act. So some people might think that's quite a low threshold. Section 33 does have an exception to automatic deportation for children, but it doesn't appear as though the definition of foreign criminal doesn't apply to them. It seems as though it does. For now, we'll see how the competent authority does that in practice. Okay, so back to the modern slavery guidance, which, helpfully the screen blocks out the date. So you can just ignore that for now, so that's fine. It's no longer that date, it's July. And as I said, the numbering is correct. So it's addressed, so this is the caseworker guidance, given them to try and make the decisions. And the public order disqualification section now starts at 14.226. In terms of evidence gathering, it outlines the process. And basically, the competent authority issue a letter or email putting the potential victim of trafficking on notice that they're being considered for disqualification. They then have 10 days to provide evidence or make submissions as to why a decision shouldn't be made, and the decision should be made within 30 days. Now, those of you who are familiar with delays in national referral mechanism decision-making may be surprised to hear this, but so far they seem to be sticking to those timeframes. In fact, I had one this week where they made a decision before the 10-day window had expired. So yeah, they seem to be really on it, and they seem to be churning them out at the moment. So how do caseworkers, what guidance is given them to making a public order notification? There isn't that much detail in this guidance, just to highlight, but they're meant to make a reasonable assessment as to whether, in respect of receiving modern slavery specific protections only, the individual is a high or low threat to public order, and whether they have a high or low need for modern slavery specific protections. So it's basically a balancing exercise between how much of a threat they are against how much they need support. There's then a non-exhaustive list of indicators for them to be used, and just to highlight some of those. So they do acknowledge age and maturity, and they're relevant indicators that indicate that the threat is low and also that the need of support might be high, but that's not simply on its own. The other thing to highlight, that one of their indicators that the threat might be low, so this doesn't mean that it is low, that it might be low, is if it's accepted that the offence was committed as part of their exploitation. So even if it's accepted that the offence was committed as part of their exploitation, they still might be considered for a public order disqualification. There's specific guidance in relation to children. They say that decision makers must keep in mind the child's added vulnerability, developmental stage of maturity, and possible grooming by the perpetrator. The guidance is silent, however, on what impact that should have or what they should do, or just keep it in mind. So there's no more information as to that, or how it applies to the actual decision. And then importantly, they say that no child's case should be considered without contacting the local authority in order for the local authority to be given the opportunity to provide further information. And then obviously best interests is highlighted as being a primary consideration, but they emphasise that it's not the only consideration. Right. So I'm afraid, as I said, this is a very quick overview. So probably the bit that you most want to hear about is how we challenge these decisions. It's going to be really brief. There's no reconsideration or right of appeal to these decisions. So it's important to bear that in mind when people are being referred to the national referral mechanism prior to the reasonable ground stage. It might be something that people want to consider at that stage. And they obviously can be challenged by judicial review. I know that there are people in the audience who've brought some judicial reviews, and several of us have in chambers, and we're challenging both the individual decision and also the statutory guidance itself. And obviously, because it's incompatible with ECAT and also Article 4. However, if you're disappointed that there isn't much in this lecture about how to challenge it, luckily enough, we have a free webinar coming up on Monday, the 17th of July. So you can all log on to that and hear more about actually how to go about challenging them. Thank you.
Gemma, and as she's just pointed out to me, she was within time. So that is the way we're going to continue. But we're going to hand over now to Jen and Maria, who, as I've said, are speaking about criminal justice process and procedure, and then Maria about the remand of children into adult prisons. But Jen first.
Thanks. Okay, no pressure. This is going to be a bit of a whistle-stop tour. I'm just going to cover essentially why not to prosecute children victims of trafficking, and then in particular what to do if it's not really clear if they are a child or not, which is of course where it gets particularly tricky. So I am going to be quite brief. I will happy to take questions at the end of all of this if there's anything further to go into. And I want to look really briefly, firstly, about how decisions are made to prosecute children and victims of trafficking, how to challenge those decisions if they're wrong, and then, as I say, to look into a little bit more detail about what you do when someone's age disputed and you don't know whether they're a child or not. And Maria is going to follow up with some more detailed examples about age disputed individuals that we've seen recently, and particularly in the sort of cases that Sonali was talking about, those charged with the new offences under the Nationality and Borders Act. What I'm going to talk about is relevant to the Nationality and Borders Act and those offences, but obviously it's relevant to all children victims of trafficking. So that will include those children who are trafficked internally, who might have conclusive grounds decisions, for example, who are victims of criminal exploitation. So it covers the whole ambit of those people who fall into that category. So the first point that I really want to make is that looking at how you make decisions about to prosecute children is to recognise that the youth justice system is fundamentally different to the adult justice system. It's underpinned by Section 37 of the Crime and Disorder Act that says that the principle of the youth justice system is to prevent offending by children. And the differences in how you treat a child in the criminal justice system to an adult starts at arrest and starts at the rights of the police station. I don't have time to go through the whole youth justice system now, so I'm starting with the decision to prosecute because that's what we're looking at today. But it's important to recognise that those rights really flow through everything from arrest going forward. But starting today with the decision to whether or not to prosecute. And I've put on the slide the code for Crown prosecutors, which is easily available online. I'm afraid I haven't put the link on, but it's very Googleable. And this is true for any prosecution, child or adult. Any prosecution has to meet what's called the full code test, which is 2 stages. It starts with the evidential test, which I'm not looking at, but importantly, the public interest test. And as I put on the slide here, it said quite straightforwardly in the code that just because there's a crime has been committed or there's evidence of crimes being committed doesn't mean that the CPS has to go on to prosecute that person. And when deciding whether or not it's in the public interest test, there are 6 factors that I've listed on the slide. And there's quite a lot of detail in the code about what those factors mean. I'm not going to go through all of them. When looking at victims of trafficking, culpability is very important. Obviously, if you've been trafficked over here, or your offence is result of being trafficked, your culpability may well be low or 0. But perhaps unsurprisingly, what I'm focusing on today is the age and maturity of the offender, which is particularly relevant to whether or not they get prosecuted. And I've set out on this slide a lot of what the code says about whether or not to prosecute children. It's important to note this doesn't just deal with children. It also, towards the bottom of the slide, talks about young adults and points out that people continue to mature into their mid-20s. Chronological age is only part of it. Suspects' maturity is also taken into account. And the younger you are, essentially, the less likely you are to be prosecuted. Not only that, it references well-known international law like the UN Convention of Human Rights of the Child, and points out that the prosecutors have to consider not only the principal aim of the youth justice system that I've just referenced, but also the welfare and the best interest of the child in deciding whether or not to prosecute them. In addition to the Code for Crown prosecutors, the CPS have very specific guidance for different offences. So, for example, there is specific guidance on the offences under the Nationality and Borders Act. I'm not going to look at that today, but there's specific guidance on children and specific guidance on victims of trafficking. Very briefly, CPS guidance on children as suspects or defendants, again, makes the same key points. That there's a fundamental difference in deciding whether or not to prosecute a child. Child first justice is the belief that children coming to the attention of the youth justice system are seen as children first. And the primary focus is on prevention diversion. And again, the guidance references, I haven't listed it all here, it references the UNCRC, it references a lot of international principles, it references the principal aim of the youth justice system, and it references Section 44 of the Children and Young Persons Act, which is the duty of every court dealing with a child to have regard to their welfare. The guidance on modern slavery, again, I put a link there to it. Again, it's lengthy and detailed, and I haven't set it out all here. There's a 4-stage test to decide whether or not to prosecute someone who is a victim of trafficking. In reality, I'm not sure this adds much to the general principle of the codes of Crown prosecutors, because essentially questions 1 to 3 are, is there evidence to prosecute them, which is the evidential test, and question 4 is the public interest test, isn't it a public interest to prosecute? But nevertheless, there's quite a lot in the guidance about whether or not you should prosecute victims of trafficking. And essentially, in a lot of the cases, obviously the public interest is going to fall on the side of not prosecuting them. So the guidance in itself isn't necessarily that bad, or it isn't necessarily that incompatible with other duties we see, such as Article 4. The question really often is what to do if the CPS don't follow it, and what to do if you have someone who you think on the guidance, because they're a child, because they're a victim of trafficking, or indeed both, they shouldn't be prosecuted. And to some extent, Sonali covered this in her slides. I'm not going to entirely repeat it, but there are essentially three main points I want to make under it. One is a decision by the Crown Prosecution Service is amenable to JR, and there's case law on it. And helpfully, especially in the guidance that to the CPS themselves, which I've just referenced, on prosecuting children, it references several times that prosecutions for children are amenable to JR. So the CPS themselves are very, very aware that they can be JR'd on this, which helps when you're writing pre-action letters. The second point, of course, is that they are a public body, and therefore they have to comply with the Human Rights Act under Section 6. And finally, as Sonali pointed out, increasingly the courts have entertained applications for abuse of process. And in particular, that case law is about prosecuting victims of trafficking. In the case of AAD, was a victim of trafficking who was prosecuted. Some of whom pleaded guilty, but nevertheless successfully applied appeals to the Court of Appeal against their convictions on the grounds they should never be prosecuted in the first place. And that's a really important case to look at if anyone's looking at challenging the decision to prosecute, in particular because in AAD, the Court of Appeal said quite a lot about how JR is probably not the best way forward, and everyone should be bringing it as an abusive process. So if you are looking at doing that, I would really recommend reading the AAD judgment in full, because it is very much the leading case now on how to challenge prosecutions. But it does say, as you can see from the quote I put on the slide, that if you're running an abusive process, the grounds are those corresponding to public law grounds. So it's basically the same argument, have they followed their guidance. And what's particularly important in the Nationality and Borders Act cases is some of the quotes you saw on Sonali's slide, which is the fact that both Parliament, when they were passing the legislation, and then Mr. Justice Kavanagh, when he was ruling on it, have relied on this guidance and this discretion as to whether or not to prosecute as a way of saying the UK is complying with its duties under the Refugee Convention. And whatever you think about that, it's an extra argument to use if you're trying to stop someone being prosecuted, that they've got no defence. And the only way the UK can comply is if this decision whether to prosecute is taken properly. And so therefore that decision becomes all the more important. And I would argue the court therefore should have extra scrutiny over that decision if you're making that decision. So that's important to understand in order to go, well, I mean, the point is really that whether or not your child is really, really important, because you get all this extra stuff, which doesn't work if they just drag you off the boat and go, well, actually, maybe you're 25 and therefore we're not going to apply any of this to you. And so that's where it becomes really problematic when we get age disputes. I've just got 2 minutes on age disputes because Maria's going to talk about it in a bit more depth. The basic way that age disputes work in the criminal courts is under Section 99. There was actually some other sections, but they all say the same thing, of Children and Young Persons Act, which says the criminal courts are basically just allowed to decide how old you are. But it does say a couple of things. It does say that they shall make due inquiry as to the age of the person. And that's been used in a couple of cases. I've put the case of Ellen, others, and put the case of Steed on the slides, but there's a number of cases that basically say, because Section 99 says the court should make due inquiry as to the age of that person, the courts usually should adjourn and find some evidence and not just make it up on the spot. Some of you will be aware of Merton compliance age assessments, and again, there's case law saying the courts should be doing essentially the same thing. They shouldn't just be looking at someone in the dock and going, well, you've got a beard, you're probably 25. They should be adjourning and making proper inquiries as to who someone is. A lot of the case law, a lot of the ADCS guidance, which I think you heard about a bit earlier on today, isn't well known in the criminal courts. So that case law and those guidances are also relevant to the decision in the criminal courts, but because it comes from sort of a different area of practice, it's not unusual for criminal courts not to be aware of it. And so it's important, if anyone's supporting someone in the criminal courts, to try and make sure that people are aware of what's on that case law says. The criminal courts do make their own decisions. So if there is an age assessment, that does not bind the criminal courts, but it does carry significant weight, and there's a case on that I put on the slides. An important point to note, I think, and this comes from a case of O that I put on the slide, and I put a very long quote from it, sorry, I won't read it all out. But I think this is important, is that when it's not clear how old someone is, everyone in court owes a duty to make sure whether or not you've got the right age. And case of O was a case where the girl was trafficked over for prostitution, and initially she said she was 31, and then she said she was 17, but she gave a date of birth meaning she was 16, and so she was all over the place in terms of her age. But it was eventually accepted that she was a child, but no one in the criminal court seemed to pay any attention to that and sentenced her as if she was an adult. And there's a great, I should have highlighted, there's a great phrase in the middle of this quote where it says, well, this Court of Appeal says, "We hope that such a shameful set of circumstances never occurs again." And the Court of Appeal was scathing, not just at the defence for failing to make inquiries, but the prosecution as well, and the court for failing to consider whether or not the age of the person in front of them. So it's not just like another fact in a case. And the prosecution will often come to a case and say, well, we take X stance. We think we've got evidence that, I don't know, you stole something from a shop. And they'll take the same attitude to age. We think you're an adult. And it's not good enough. And they also owe duty to make sure they get the age right of the person in front of them, because so much flows from it. And finally, before I have to sit down, my last slide, I promise. As I say, Maria is going to talk a little bit more about practical issues. So there's good guidance, really. It's just not always applied. And there's good case law on what the criminal court should do in terms of making sure they get the age right. There are a lot of practical problems. And I've put some of them on the slides. Essentially, what should happen if a child or a putative child comes before the criminal courts and says, I'm a child and there's an issue, is the court should adjourn in order for an age assessment to carry out, or some inquiries, so that court can make a proper informed decision. The first issue is, if you adjourn a case, is you have to consider what happens to bail. And bail is different for children than it is for adults. Here, the most useful case is the one of M versus Hammersmith Magistrates Court, where the court in those circumstances, the High Court in those circumstances, said that the putative child should be remanded to local authority accommodation. That is essentially treating that person as if they were a child pending an age assessment. So it was giving that person the benefit of the doubt in terms of the bail decision. There are other significant problems, though, with courts questioning whether or not you should maintain your credit for a guilty plea. Obviously, age assessments take a long time sometimes, and sometimes they're challenged, and that causes delay. There are issues to do with, I should say that courts are not bound by previous age assessments. So just because one court has deemed someone to be an adult, that doesn't prohibit the next criminal court coming back and making a new and fresh decision. And I've put on the slide the Crown Court can now remit a case back to the Youth Court, and the reason that's important is it means that if a case ends up in a Crown Court because everyone thinks the person's an adult, but it turns out and it's accepted that the defendant is a child, the Crown Court can send the case back to the Youth Court, and that's only a new provision that was brought in last year. But I want to end on one note, which is the last point I've made, is that if at all possible, it is very important that age disputes are raised during criminal proceedings, because it is incredibly complicated, and I'm now involved in a couple of cases where we're trying to undo the damage that's done when someone has pleaded guilty as an adult or thought to be an adult, and then they're being recognised as a child, especially because if you plead guilty in the magistrates court, there's no route of appeal, you have to go by the CCRC, which takes about 5 years. So that is a very whistle-stop tour of things, and I'll hand over to Maria, who I know is going to continue with the theme of age disputed children in the system.
How do I get rid of that?
There we go, thank you. Thank you. And so carrying on from Jen's presentation, I'm going to be looking at the complex situation when someone who is an age-disputed putative child or a potential victim of trafficking is charged with one of these newly introduced Nationality and Borders Act offences, and as a result is remanded into an adult prison. And I just note the information that Sonali shared about the small percentage of these prosecutions. But in my experience since last year, and some of my instructing solicitors who are in the room, I've been involved in a number of cases where there are age-disputed children who are being prosecuted. And so there must be more cases. So I'm going to start by just setting out the factual context that gives rise to this situation, and then share some thoughts and suggestions on practical steps you can take if you do come across one of these cases, and legal issues and potential challenges to be aware of. So there are three main contributing factors that create this situation where putative age-disputed children are spending prolonged periods of time in an adult prison. The first one being the Home Office's approach to disputing age, and that, as we all know, happens immediately on arrival. The second is the police and CPS's prioritisation of a speedy charging regime of these Nationality and Borders Act offences. And the third is a lack of awareness within the criminal justice system of age disputes. So that being either age not being raised at a very early stage in proceedings, limited understanding of amongst criminal representatives and the court, and just how unreliable the Home Office's age determination is, and taking it as a given that the Home Office's allocated date of birth should be afforded some weight, and also appropriate steps not being taken to ensure that age is lawfully determined. So the trigger of the situation is the Home Office's age determination, which is made pursuant to their assessing age policy. And I won't go into great detail because I'm sure everybody here is aware of what that entails. It is really no more than a very brief meeting that takes place almost immediately after arrival, with no time allowed to the individual to recover from their journey, a potential near drowning experience, or even sometimes change into dry clothes. There's a meeting, a brief meeting conducted by two Home Office officials or a Home Office social worker. And in some recent cases, there wasn't an interpreter provided either on the phone or in person. And the assessment is based almost entirely on physical appearance, which we know from case law in the age dispute cases is an inherently unreliable indicator of age, particularly in those circumstances when somebody's just arrived and they're tired and exhausted. And so the result of this is that the Home Office allocated date of birth for the age group, usually at 16, 17, when it's very difficult to determine accurately their age, and there's no documentary evidence of age or date of birth. So they're allocated a date of birth by the Home Office that makes them an adult. And importantly, at this point, the Home Office are not making any referrals themselves to a local authority to request that a Merton compliant age assessment is conducted. And yet there must be some information sharing between the Home Office officials and police, because what's happening in these cases is that after the Home Office very quickly deem them to be an adult, they're then transferred into immigration detention. And within 24 hours, the Kent Police arrive specifically for the individuals and arrest them, take them into police custody. And that's where they're then charged with offences of legal arrival, facilitation, and potentially manslaughter. So in cases where they are being accused of piloting the boat when there have been deaths through drowning, there's also manslaughter charges that are being laid. At this point, again, importantly, neither the police nor the CPS are triggering a referral to the local authority for a Merton compliant age assessment. And although the young person may have access to a duty solicitor at the police station, they're not always alert to the issue of age and the relevance of that. After the young person's charged, they're then brought for a first appearance before a magistrate's court, where bail is not sought, and they're remanded into custody, treated as an adult, again, off the back of the Home Office's very cursory age determination, and placed in an adult prison. So it's really clear that in the early stages of the criminal justice system, age is not being raised either with the police, the courts, or the prison service. And it's also clear that on the relevant paperwork, the Home Office's allocated date of birth is the one that is recorded. There is no indication on the face of the documentation that there is another claimed date of birth that would alert others to the fact that this could be a putative child. The young person, slide. I think it's in the wrong order. I'll go back to the slide in a minute. So then what happens is this young person is remanded into an adult prison. Again, we know from the cases that I've been involved in that the only date of birth that's recorded on the prison intake information is the Home Office's allocated date of birth. So the prison have no awareness that this could be a putative child. Therefore, there is no risk assessment undertaken. They're automatically being placed in shared cell with another adult. And there's no referral by the prison, again, to a local authority for a compliant age assessment. But from the young person's perspective, within a matter of 2 or 3 days of having arrived in the UK, they find themselves remanded in an adult prison with very limited awareness of what's happened, the consequences that flow from the Home Office's age determination, and with very limited access to advice or an ability to seek a lawful determination of their age themselves from the local authority. So in the rare cases that we've come across where these young people have somehow managed to reach out and make contact with a charity who's then referred them to a solicitor, there have been steps that have been taken and that can be taken to try and address some of the potential harm. So this slide just sets out practical steps if you do come across some of these cases. The first is to make a safeguarding referral to the prison, and that's often the first point at which the prison may become aware that there is a potential child remanded into their custody, and request at the same time that there are interim safeguarding measures implemented. The most obvious one would be that they're placed in a single cell, pending further inquiries into their age. Also, it's important to make an urgent referral to the local authority, requesting that they firstly conduct a welfare visit to the young person in prison. And that's usually the first step that a local authority will take. Depending on the strength of that young person's positive account on age, you can also ask at that point whether the local authority will just accept claimed age, or if not, whether they'd agree to undertake a full age assessment. And if they do, then they are accepting that they're exercising the benefit of the doubt, and they're accepting that that person could be a child. And this was covered earlier in this morning's session in relation to the provision of Section 20 accommodation. So if pending an age assessment, a local authority should treat the young person as a putative child and accommodate and look after them as such. And in this context, that means getting an agreement from the local authority to provide Section 20 accommodation in support of a bail application that can then be made by the criminal representatives. And also at this point, it's important to flag to the local authority as a first responder if you have identified potential indicators of trafficking and request that an NRM referral is made. Alongside all of this, it's really important to also try and start collecting evidence in support of the age assessment, albeit that's going to be very difficult when you have limited contact with a young person who is in prison. It's difficult to arrange visits. It's a really difficult environment in which to take instructions and try and get information to help you try and creatively pursue avenues to obtain further evidence. But it's really important to work collaboratively with the criminal legal representatives for a number of reasons. Firstly, it's important to understand the stage at which the criminal proceedings are at. So often these cases have come to our attention really at quite a late stage, which means that it's really important for a local authority to do an age assessment on an expedited timetable, before there is either a trial or sentencing hearing. Although the next section addresses what the criminal representative should also be doing, which is seeking a stay of the proceedings pending an age inquiry conducted by a judge, which should be informed by the local authority's age assessment. And the criminal representatives should be making an application for bail, ideally supported by a local authority who's willing to offer a bail address on the basis that they're willing to conduct an age assessment. But that's not necessarily straightforward, because there have been cases, particularly where there's been a manslaughter charge, where the judge hasn't been satisfied that the Section 20 accommodation that's being offered, which is by Kent, it's Appledore, which is a reception centre for age disputed children, is appropriate, or given the flight risk and other considerations for bail, and so bail has been refused in some of these cases. Which brings me on to the next slide, which is considerations, legal issues that arise. If bail is refused or hasn't been sought, it's still really important to really push the local authority to conduct an age assessment, but necessarily that will mean that it has to take place in an adult prison, which is far from ideal and gives rise to a number of procedural fairness concerns. An adult prison is not set up for an age assessment to be conducted in a calm environment that allows a young person to disclose their experiences. But it's still sometimes necessary to get a lawful determination of age in the circumstances. There is no HMPPS policy specific to this cohort. So age disputed putative children whose age is unresolved pending an age determination by the local, an age assessment by the local authority, whilst they remain remanded in adult prison, which means that if you do make a safeguarding referral to the prison requesting that interim safeguarding measures are implemented, there are inconsistent responses that come back. Sometimes a refusal to take any steps on the basis that the criminal court's remand decision dictates the venue for remand and therefore ties their hands. This is problematic and reveals, oh, I'm running out of time, I know, sorry, a lack of awareness about the wider statutory framework that applies to safeguarding particularly putative children. I've just flagged the policy that was recently published, HMPPS guidance for modern slavery victims in prisons. In these cases where there have been age disputes and indicators of trafficking, there has been non-compliance with this guidance. And also just going back to Jen's point, that the other thing to consider is if you get involved in a case where there is already a conviction and a sentence, and then a young person later comes to the attention of a local authority and is found to be a child, to be alert to the fact that there is a possibility to try and take some steps to appeal the conviction, because there are wide repercussions for the asylum claim and the potential public order disqualification decision if they are an adult. Thank you very much. I've overrun.
Thank you very much, Jen and Maria. I'm sure you'll agree, a really interesting talk on the interaction of this is deliberate, by the way, it's not a protest. Interaction between the criminal justice system and age disputed children in particular. We have a set change. Our final three speakers are now going to come up, and as I mentioned, they are speaking about missing asylum-seeking children and Home Office policy, in particular the case that they did together earlier this year in the Family Division in front of Mrs. Justice Loughran. I've introduced them all to you, and I believe Caroline is starting.
I am, and hopefully you can see me, but if you can't, then that's also symbolic, isn't it? So I'm going to, in 5 minutes, hopefully throw something at me when I get to 4 minutes. Talk about three things. What's been happening to children who remain missing from the hotels run by the Home Office? What have children been denied, and where are we now? So we go back 2 years to July 2021, when there is an influx of children who need our protection in our country, children who have come in the most perilous, treacherous, frightening ways, and who the law says we are there to protect. The Children Act 1989 does not distinguish children on the basis of how they became to be without their parents, without parental care, how they became to need state protection, or how they became to be harmed. So the law was there. Our child welfare system was there. Our children's care system that goes all the way back to the workhouse system, and then local authorities moving away from workhouses. So all that was there for them, except our children's care system held up signs saying we are closed. We don't have space for this group of children. So a deal was struck between the Home Secretary and the Education Secretary to put these children into hotels run by the Home Office. In my view, this was a prime ministerial challenge. And it could have been the welfare department, the department that deals with child welfare, and ought to have been the Department for Education that got the responsibility to get this sorted and to get the money from the Treasury and the rest of government to rally round and sort the children's care system. So children, there's over 4,400 as of January 2023 that had been put into Home Office hotels run by the Home Office. Home Office pays the owners of the hotels, but the Home Office then runs the hotels. As of yesterday, there are still 154 children missing. The Home Office has a sigh of relief. Ministers from the Home Office saying, oh, 100 of those are now adults. Well, how many parents, how many grandparents, how many directors of children's services whose children go missing and then have their 18th birthday when they're still missing say, oh, they don't count anymore, they're not children anymore, we can rest easy. What have they been denied? They've been denied all of the things Kathleen and others throughout today, Kathryn, set out that the Children Act and all the associated regulations and statutory guidance and the non-statutory guidance provides for these children. They ought to have had health assessment on arrival. They ought to be allocated an independent reviewing officer. They ought to have statutory reviews. They ought to have education. They ought to have social workers. They ought to look forward to protection and care and assistance to the age of 25, if not beyond. If they were in children's homes or foster care, there are dedicated regulations and statutory guidance to protect them. And there is statutory guidance that says bed and breakfast accommodation issued by the Department for Education is absolutely unsuited to children. So if bed and breakfast accommodation, our government is telling us quite rightly in statutory guidance cannot be used by local authorities, why on earth can hotels be used for children? And this includes primary aged school children who have been put into hotels in rooms on their own. January 2023, the Observer newspaper reported that dozens of children had been abducted from the hotel in Brighton and Hove, which is where our case came in. And then recently, Channel 4 News has reported, through Freedom of Information requests, has reported that missing children found in Sussex and Kent by the police in those police force areas were found on 22 occasions because they had been arrested, and one 15-year-old child had been arrested for producing cannabis. Kent Police Force has reported that they are investigating 4 crimes committed against missing children, 3 concerning exploitation and 1 where there's a reported assault. The Home Office that on behalf of our whole government has taken it upon itself or been given the job by the Prime Minister to look after these children, has reported very recently to Parliament that it can't give any data on the number of police forces that are investigating crimes committed against children, because that information isn't collated or held centrally. So yet again, the Home Office is behaving as it always behaves, rather than in its new role, the role that has been created for it as in a parental role of very extremely vulnerable children. The Home Office is also stating that it cannot give stats on the numbers of children that have been put into hotels by age since July 2021, because the databases are not quality assured. This is basic information. You'll have heard that the Home Office is also promising to amend its policy on use of force in order to be able to carry and cajole and restrain children onto aircraft to make them leave the country. And then we have Mickey Mouse and Baloo from the Jungle Book. And just this week, the Minister for Immigration told Parliament that it was clearly the correct decision to have those walls painted over in the Kent intake unit, because these facilities are for detention purposes. It's a detention facility, he said, for those who have entered the country unlawfully, and it is appropriate that it is decorated in a manner that reflects that purpose. So we have a government department who does not see children, yet we have a child welfare system and child welfare legislation that is crafted and has been built and designed and developed because we see children. We have a government department that is prepared to act with cruelty and has acted with cruelty and unkindness. And it is about, through the Illegal Migration Bill, to gain far more statutory power to act and to be emboldened in its actions. My background is social work. I got into children's rights amid the institutional abuse of children in previous decades. And what my time in children's rights and looking at institutional child abuse has taught me is that when you have a hunch that an individual or an organisation or a place or a setting is being cruel and abusive to a child, you follow that hunch. You don't let it drop. You don't say, that's unbelievable, that can't be happening. And here we have a Home Office, a government department that is telling us this is what we're doing and we can get away with it.
And that was very powerful, and those figures that you gave for missing children, including on an ongoing basis, are absolutely frightening. And we're now going to hear from Polly Jackman of the Good Law Practice.
Hi everyone, I am going to keep this very brief. As Caroline, I think, mentioned, I worked with her and Amanda, Naomi Wiseman and Professor Rob George on an unaccompanied asylum-seeking case earlier this year where we applied for wardship. We made the application in Article 39's name, which was a novel use of the law. And while we weren't successful in obtaining wardship, I think that it really helped to change the sort of landscape that we're seeing at the moment, although obviously it's pretty hostile. But as far as I'm aware at the moment, there are no children in hotels, and we think that the pressure that was caused by that case had something to do with that. So I've been asked to talk about Good Law Project and the way that we work, and I will keep it brief. So Good Law Project is a not-for-profit that brings and funds strategic litigation in the public good. And it does this by also trying to win as many cases as possible, but kind of taking a holistic approach around that. So it views litigation as a place of creating awareness, publicising causes, encouraging public debate, and kind of pushing the envelope as much as it can
in the right direction. That is largely around storytelling. So using the press as much as possible, using people's individual stories, as well as trying to use strategic litigation as far as we can. So some of the cases been involved with, people are aware, that include the prorogation of Parliament in 2019. So we mounted a successful challenge against that. The A-level algorithms case, which, if everyone casts their minds back to the pandemic, that was when Gavin Williamson decided that pupils would be ranked by an algorithm, basically, in terms of their expected grades, not based on their past performance or what their teachers thought, but based on the quality of the school that they went to, essentially. Which meant that many children who were kind of high achieving but maybe at poorly performing schools lost out on places they were expecting to get. Now, that case didn't go to court, but the public outcry and the pressure that was brought by us, I think, issuing doing pre-action protocol correspondence, obviously also Marcus Rashford, I think, had a massive a lot to do with that, kind of created this pressure that then saw change, and they resiled on that position, which was in the public interest for everyone. And we're also particularly interested in novel points of law. So the Article 39 challenge is a really good example. But also we're in court last week using the public trust doctrine, which is a really old piece of law from 1299. I'm holding my notes. And basically arguing that the state has a fiduciary duty to safeguard natural resources. So we were arguing about storm overflows, which is boring, but it's basically the discharge of sewage into rivers and coastal waters, and trying to get the government to realise that it probably shouldn't do that anymore. So fingers crossed, we should have the judgment on that soon. So GLP is basically primarily funded by members of the public, giving us direct debit donations. So we've got unrestricted funds and a wide remit, and we're not a charity, which means that basically we can look at interesting cases that were brought by organisations or individuals. And we tend to focus on 3 strands of work, which are called holding power to account. So that's kind of governance work, but also looking at shady business practices. So we've been looking at what we call dark money and sort of Tufton Street and the influence that that's having over government as part of that strand. Secondly, protecting the environment. So that's lots of cases on clean waters and rivers, the way that we treat our natural resources. And then finally, no one left behind, which is our work that helps marginalised communities. So that's probably relevant for most of the people in this room. And we have found that that's a really challenging area in which to find strategic litigation, because it's primarily cases on behalf of individuals. But because we take more of a holistic approach, it doesn't have to be a public law challenge. If we can find a story in an individual case, then we can tell that story, then we may well think about bringing more funding that claim. And I think GLP will be looking into moving more into kind of larger casework or policy work in the future as well. So I think that's just to say, I want to encourage anyone who has an idea for litigation that might address or affect a disadvantaged community, and particularly where it might otherwise be unlikely to be litigated, to please get in touch with Good Law Project to see whether they'd be willing to support and fund it. You can get in touch with me. I'm at Good Law Practice, which is an independent law firm. So majority of our work is for Good Law Project, but we do work for third parties. And if you come to me, then I'll probably get the glory of having brought them lots of good ideas. So I'd encourage you to do that. And they do put money into great legal teams. Like the Article 39 challenge was, pulled together really quickly, and we had a really great team. So if there's a good campaign there, please let us know and we'll do what we can to help.
Thank you very much. A lot of the good campaign and policy work is being done by the Good Law Project and Marcus Rashford. So maybe we need to engage them in future. Yeah. So our very final speaker, last but very much not least, is Amanda Weston, KC.
By my account, I had 1 minute left when I stood up, but it's gone. So I'm not going to take very long. I know the questions are going to be much more important for people. I'm just going to talk a little bit about the case that's been mentioned a few times today. The use of the High Court, the Family Division's inherent jurisdiction, what's sometimes termed the parens patriae jurisdiction, the burden, the duty on the Crown to take care of people who don't have anyone to take care of them, children who don't have a parental, anyone parentally responsible for them, and vulnerable adults who are unable to take care of themselves and to protect themselves from harm. So the public law problem has already been touched on several times. I'll just put it in a nutshell for you. Putting children in hotels, 600 over a course of a year, and not putting a local authority in a position where they've got any say over the extent to which their resources can extend to ensuring that those children are properly covered by Section 20 of the Children Act and the other obligations that you've heard about today, is obviously it's a disastrous policy. And the fudge that resulted was a situation where local authorities and the Home Office were between them forwarding, promulgating the fiction that there was a lacuna in the law, that these children fell between the gaps. And now, of course, we know, certainly as a result of the judgment, that that was a fiction. It was a total fiction. But the problem was a practical one. How do you protect the children? What do you do about missing children in that situation where local authorities have made it absolutely clear, and Brighton did, and so did Kent, that they can't put into effect their obligations to very vulnerable children in circumstances where the numbers arriving are obviously beyond their resources, but importantly, and this is something that came out during the Article 39 challenge, the Home Office did not conduct proper risk assessments. They didn't know what the vulnerabilities or the particular risks to the children were when they placed them in the hotels. As the Independent Chief Inspector of Borders and Immigration, in his report, which I'd recommend anyone read, which was released in October of 2022, made clear, everybody at the Home Office was very anxious that they were acting unlawfully, and everybody was very anxious about what the position was in law in regards to the children, but nobody was doing anything about it. It was a lot of hand-wringing, and people saying, well, this is a temporary option, but obviously 19 months later, by the time we heard our application, it was still going on. So then there was a problem about what's to be done, and the problem about bringing judicial review in circumstances is that who do you bring them against? Who do you bring judicial? Who do you bring them on the behalf of? None of the identities of the children were known to Article 39 or to the Children's Commissioner. The Home Office had the information, but were holding on to it for confidentiality reasons. So the question was, what role does the Family Division have in its parens patriae jurisdiction, the duty on the Crown to take care of the vulnerable people in the jurisdiction, and indeed British people outside the jurisdiction? It's been used for that as well. Where there is a statutory arrangement, but no one's adhering to it. So then you test it. Because the court in the Family Division has got very extensive powers, including the power in respect to the missing children to order their identities to be disclosed to it, including bringing in the children's guardian, bringing in CAFCAS and appointing a children's guardian, making those children parties, making location orders, sending out the venerable tipstaff with all his powers, and the powers of disclosure on the police, on social services, on schools, on companies, on private organisations to disclose the whereabouts of what information is held, on telephone companies, on mobile phone companies. All that was possible through the inherent jurisdiction. When we got to court, of course, the court was faced with the CAFCAS representative saying, this is the last thing we want, children on our desk, and with the Secretary of State for Education saying, well, of course, we always said there was Section 20, and of course they had. but they weren't making the decisions and it wasn't their policy. So interestingly, what did the Secretary of State for the Home Department have to say about this policy? What explanation did they give to the High Court judge that was asking them for some information about these children? They gave them a table, and they sat down, table with names of children on and their ages, and then they sat down and left it all to the Secretary of State for Education to try and explain. And when you read the judgment, you can really see that the Secretary of State for the Home Department took a great big step back from explaining the policy and justifying the policy. But what does come out of the judgment is something quite important, which is, one, Article 39 had standing to bring the application and nobody argued that they didn't, but that's actually quite novel, but it does set a precedent which might be useful in the future. Secondly, that the government couldn't persist in the fiction that these children were in a lacuna because it was quite clear what the solution was. And now the ball is very much in different local authorities' court. If the policy is children will start being put back in hotels, then local authorities might find, I know there's been a change of leadership at Brighton, which might result in a slight difference in approach to this government policy. But I anticipate that because it's beyond doubt, and the court has stated that individual local authorities are responsible for each and every one of these children, then it's much more likely that local authorities are going to be robust in making their representations to government that is a policy which is wholly unacceptable. So that's all I had to say about the, I think we're going to have some questions now.
Thank you.
Thank you, Amanda, and you're absolutely right. We do have time for questions. We have 10 or 15 minutes, and then there is wine, but we would like some questions and you can persuade yourself to ask some. Our speakers are all still here scattered around the room, so please do, if you have any questions arising from any of the presentations. Yes, at the back.
The Angel Hospitals in London. One of the I'm in a working group which is looking at possibilities to combine the two jurisdictions which concern trafficked children, the immigration care and crime, getting a sort of unified thought for this. One of the other things we're looking at is the appointment of a guardian for children, not a Kafka's guardian, but a guardian who would be like in loco parentis and would hold that child's hand through their journey through the labyrinthine punitive processes that they go for and would advocate on their behalf. They've got this in Scotland. I think they might have it in Northern Ireland, but we need it here.
Yes, it's been a recommendation for some time, I think. I don't know if anybody would like.
Caroline probably has got thoughts on that, haven't you, Caroline?
Well, just to say yes and to agree that it's been a recommendation for a very long time. I think for the last 3 times when the UK has been examined by the United Nations Committee on the Rights of the Child in Geneva, the most recently was this year, they've recommended that children should be appointed guardians, that it is seen as a fundamental child protection. Yeah.
Can I just say that the assessment of the guardian system in Scotland gets rave reviews, not just from people who've assessed it, but from all of the children. And when we did the study for the law centres about how their cases were compared with the ones in England, there was such a difference in the preparation, the help that England got in giving their story, help that they get in setting out chronologies and all of these things. It just is a remarkable difference in the quality of applications that are made for children.
Wholesale endorsement. Thank you very much for that contribution. Any other questions or comments from anybody?
I could just, I'll let Joey go ahead.
Thank you.
I
really want to help my boss. My boss wants to stop the boats. So I've painted over Mickey Mouse. Should I be worried that Article 39 are going to bring a misfeasance against me? Secondly, will Garden Court represent me?
I imagine we could predict the answers to both of those questions. Caroline, would you like to bind yourself?
Well, I was so angry after hearing the minister. I mean, I'm permanently angry actually at the moment. I was extra angry have to hear in the Minister that an FOI request was submitted to the Home Office last night, in fact, asking for the decision-making process. So who made the decision, date of the decision, and Section 55 of the Borders, Citizenship, Immigration Act 2009, which is the child welfare duty, asking for correspondence on that. I'm mixed on Mickey Mouse and Baloo, because if you read the illegal migration bill, every word of it surpasses the cruelty of painting over Mickey Mouse and Baloo. But it's something we can all visualise. Words are different. We have to do more work as human beings to imagine what's behind writing these words and these clauses in this bill. So Mickey Mouse and Baloo is very symbolic, isn't it? And it's something we can hold on to. Everybody in the country knows that you don't cover up things that can comfort frightened children. We just don't do that as human beings. So a case, a challenge, on the one hand, you could say, well, isn't that a bit trivial? But actually it's of such importance, because these are real people that made that instruction to cover those.
In a week where we also heard Matt Hancock talking about how the government's priority was making sure there were enough body bags at the beginning of COVID. That tells you all you need to know about the administration.
And can I just come back to Amanda, when you said about read the report from David Neal's, the independent inspector of borders and immigration. There's lots of really important content there. One of the things that sticks out for me is that children were being given takeaway containers to eat their food, and the explanation was because it wasn't part of the contract to have plates. Yeah. So again, there's lots more harm that has been inflicted on children in those hotels, but plates and not giving children a plate to eat their meal is something, again, as humans, we can all relate to.
Thank you for that question and that answer, Caroline. I think there were a few other questions, certainly one from Sonali. Any others as well?
Sorry, that was a bit long.
Yeah, that's exactly what we wanted.
Kathryn.
Just to say that one of the things we've sort of not really developed today, I think, and is really important, is just what the Border Act provision for age assessment is going to produce, because that institution they are setting up is truly horrifying, and all of the work that is now being done. We've got this interim report on scientific testing of age, where they have accepted that you can have certain X-ray assessments. And of course, the bill, the Act actually says that if you decline to cooperate with a scientific test, you can be now under the illegal migration bill, you can be assumed to be an adult. Yeah. So the whole working assumptions of our age assessment model created through the courts over extended period of time and lots of case examples is actually undermined by this really, again, really punitive and abusive structure.
We know, I agree, and we know systemically that there's a schizophrenia at the heart of the Home Office. They have proved themselves as a body incapable of taking on a safeguarding role in any context, to wit, the AAR policy, or any circumstances in which their priority is not getting someone on a plane. And the individuals making those decisions aren't assisted. They're made to, I mean, we all know what happens to the, the grant monkey phenomenon. I mean, it's just laughable that Parliament would entrust this government department with any responsibility for taking decisions of that kind.
And the other thing that I was going to say is that never forget that the Children Act says to local authorities that they have a duty to protect children who are in their jurisdiction and in need. And the fact that they're in a hotel or they're in any place that the Home Office is putting them, it doesn't take away from the local authority the obligation to be protecting them in that institution. So, and I think that we do need to face that Children Act provision.
We absolutely do, and we have to learn from the lessons that we learned when we tried to get the Care Act implemented in places of detention for vulnerable detainees.
I think there is a judicial review at the moment against
ECPAT UK. I think Patricia, are you here? Exec of ECPAT UK. I saw her earlier. So there is a pending judicial review. I don't think they've had a commission decision yet. And certainly I would, if there are still local authorities here today, and if you do happen to have a Home Office hotel in your area, fulfill your obligations, take these children to places of safety, of care and protection, then bill the Home Office, then you too scrap, rather than let's have the local authorities and central government scrapping, rather than us having NGOs having to try and find very, very vulnerable children who are already very afraid to raise their voices, to then be informing them, do you know, you shouldn't have been treated this way. And do you want to bring a challenge? That's important too, but local authorities could be much more proactive in this.
Yeah, we don't want the onus to have to be on these children to fight their own corner. That's absolutely